All rise. Please be seated. Good morning. Just every day, a few less people to welcome, but still, welcome to you all. We're going to continue the hearing. And every day we have the pleadings on the agenda. So I'm going to give you the floor again, Mr. Doeschaten. So thank you, Your Honour, members of the court, everyone present here. I just handed out an index, and it might seem as if I'm going to be reading out 270 pages today. That's not correct. I've done part of them yesterday, but it used to be one part. It was printed as such, which is why I separated the introduction. And I'll start on page 72. Yeah, I always look at the introduction, but I'm going to leave the break up to you. About an hour from now would be good. Yes, if you could just point that out at that moment. Thank you. So today we'll start, and this is a large part of the day, in fact, we'll start with witness X48. So we're left with witness X48, it says here, and that seems a bit abrupt, but that was after I intended to speak of M58, such an unreliable witness that they should not be used as evidence. So then we get the phrase that leaves us with witness X48, just so you know where that's coming from. So X48, according to Public Prosecution Service, is the other witness who allegedly saw that a Buk missile was fired from a far field near Pervomaisky. We know almost nothing about X48. At some point, a point unknown to the defense, in the winter of 2015 and 2016, that is all we know, that witness, who was later called X48, apparently was in contact with investigating officers. In an official report by a public prosecutor of the National Public Prosecutor's Office of the 15th of January 2016, we find a summary of a statement that this witness allegedly made to reporting officers. And the part of the official record relating to what X48 said covers about half a page. The reports of the interviews themselves, we don't know how many they were, have not been added to the file. So we don't know what questions were put to X48, what they were told, what he said. We don't even know how the author of the official record, about the prosecutor, how they got this summarized information. And we certainly have no information showing that this summary is a correct summary. I'm not saying he made something up, but we would like to see how it was verified. You know, that what it says is a correct representation of what X48 allegedly said. And there are no indications that that summary in Russian, as far as we know, X48 does not speak Dutch, so there's no indication that a summary in Russian was presented to X48 and that he stated that that summary corresponds to what he in fact said. On the date on which the summary was drawn up, the public prosecutor applied to the investigating magistrate for the witness to be granted a status under Article 226A of the DCCP. That means they asked for their identity to be concealed. The investigating magistrate then, on an unknown date, interviewed X48 about that application for that status in the presence of the public prosecution service without the accused being present. And on that same day of that application, when the summary was drawn up, they decided that the identity of X48 would remain concealed. Between the 15th of January and 24th of March of that year, the investigating magistrate questioned X48 with the accused and the public prosecution service not being present, but the questions of the public prosecution service were asked. Photos of vehicles and uniforms were presented to X48 at the prosecution's request. So the extensive report or the notes of that interview by the investigating magistrate were not added to the file. We only have a redacted official record, which is a very brief summary of what X48 said. The part of that redacted official record containing the statement covers about 1.5 pages. In other words, in total, we have about 2 pages with reports of interviews of a witness whose identity has remained concealed. That's the anonymous or threatened witness. The defense was not allowed to question X48, not at a hearing, not outside of a hearing, and not in writing either. For many reasons, the statements of X48 cannot be used as evidence, or at least declaring the charge is proven cannot be based on it to a decisive extent. First, I will go into the national law framework, so that's a Dutch framework, and then I will conclude that the X48 statement cannot be used in evidence. Then I will discuss the European Court of Human Rights framework in order to arrive at pretty much the same conclusion. So first, the use, which is contrary to Dutch law. An investigating magistrate can designate a witness as a threatened witness when the witness or another person, with a view to the statement to be made by the witness, feels threatened to such an extent that it may be reasonably assumed that their life or health or the safety or stability of their family life or socio-economic existence is in jeopardy. And, so not all, but and the witness has indicated that they do not wish to make a statement on account of this threat. This is Article 226A, first paragraph. The arrangement connected to Article 226A assumes a situation in which the defense has been involved right from the start in the criminal investigation. That was not the case here. I'll say more on that subject later, but that is why it wasn't possible to give the defense the required opportunity to question the witness or to have them questioned, or right after X48 was interviewed by the investigating magistrate. If the defense is only involved in the criminal investigation at a later stage, according to the explanatory memorandum, so according to the legislator, an opportunity then needs to be provided to the defense to examine that witness. And I quote from the legislative history, "It is imaginable that a threatened witness is questioned in the context of a preliminary judicial investigation against an unknown perpetrator if the defendant becomes known at a later stage and is designated in the application intended in Article 188, paragraph 3, then the defendant and their counsel should be given the opportunity then to question the threatened witness, if their statements are to be used as evidence. The threatened witness, in that case, will then have to be questioned, again, by the examining magistrate, either at the instructions of the trial judge or not." End quote. The consequence of not giving the defense the opportunity to question the threatened witness is mentioned explicitly It says the statement of the threatened witness can then not be used in evidence. And since the defense wasn't given the opportunity to question X48 or to have them questioned, the following conclusion needs to be attached to that. The statements of X48 cannot be used in evidence. And I have considered, and it would save us a lot of time, considered whether I should stop discussing X48 here, since there can be no reasonable doubt about the above. So why should I discuss alternative conclusions or European law frameworks? But just to be on the safe side, we will, unless the court is predisposed to decide and confirm that X48 is not going to be used in evidence. In the alternative, I'm just going to assume you're not going to answer that question, so in the alternative, I will continue. In the alternative, based on Article 344A, and this is still Dutch law, so based on 344A of the DCCP, Dutch law precludes the charges being declared proven based on the statements of X48. The first paragraph of Article 344A says that the court may not find that there is evidence the defendant committed the offence as charged in the indictment exclusively or to a decisive extent on the basis of written materials containing statements of persons whose identity is concealed. So if X48 may be used as evidence, then the charges cannot be declared proven exclusively or to a decisive extent based on their statements. Because X48, as you can tell from the name, is a person whose identity is concealed. And it is the only witness, since M58 cannot be used in evidence. So it's the only witness cited in the public prosecution's address demanding sentence as independent evidence showing that MH17 was downed by or with the Buk missile transported by the DPR or through the DPR. Or in other words, the Buk missile that a client is connected to, according to the public prosecutor. Without X48, all there is, if there is even that much, is that in and or by members of the DPR, a Buk Taylor was transported on the one hand, and that MH17, if that could even be determined, was downed by a missile, potentially a Buk missile, on the other hand. So on the one hand, you have a missile in the DPR, on the other hand, you have that MH17 was allegedly hit by a Buk missile. But the link between those two events, so between that missile and MH17, cannot be established without X48. Because then there is no evidence that MH17 was downed by that, let's call it the DPR Buk missile. Nor is there without X48 anything that might show the alleged involvement of our client in downing MH17. And regardless of the whole issue, about the alleged role of client and whether it's a criminally culpable one, we'll be discussing that under subquestion 3. So regardless of that question, without X48, a connection between our client on the one hand and a missile allegedly used to down MH17 on the other hand simply doesn't exist. All the other evidence asserted by the public prosecution service, including intercepted conversations, context, supply, removal, so all that other evidence, let's call it, could at most, though it doesn't, show a connection with the Buk missile transported in or by the DPR, not a relationship with the Buk missile that allegedly downed MH17. And if MH17 wasn't downed by that DPR missile, then the alleged involvement of our client with that missile is not relevant to the current case. In other words, it is X48 exclusively, and at least to a decisive extent, who in theory could be the evidence that the defendant committed the offence with which he's been charged. He is essential for the charges being declared proven. Everything else has been asserted by the public prosecution service for evidentiary subquestion 2, excepting M58, but they no longer count, can only be seen as supporting evidence. And apparently the Public Prosecution Service feels the same. We can deduce that from their address, where they considered, connected to the smoke plume, for example, that these statements in and of themselves are no proof for the firing site, but they align closely with the statements of X48 and M58. The defense therefore takes the position that X48 is a witness within the meaning of Article 344.8. That article precludes judicial finding of fact based exclusively or to a decisive extent on X48. And also, according to the Dutch Supreme Court, such a judicial finding of fact based on Article 344A is not allowed. That takes me to the European law framework. And really it's not necessary to go into this because the Dutch law precludes the statements of an anonymous witness like X48 being used as evidence when there was no opportunity to interview that witness, or at least they're being used to a decisive extent for declaring the charges proven. There are no further demands imposed on that. No matter potential compensation, it's simply not allowed. And like I said, that could be a reason to not go into the sometimes slightly more capricious case law of the European Court of Human Rights. A national legislator can be stricter than European courts. And even if the European Court sees more room, the national, more stricter law cannot be deviated from. However, if the court were to have a different opinion, we will also discuss the European Court of Human Rights framework in order to conclude that a judicial finding of fact based on the statements of X48 would constitute a violation of Article 6 of the European Convention of Human Rights. First, the legal framework of that European Court of Human Rights, and I'll just warning you now, this is going to get pretty technical for all non-legal experts here. First of all, it's important to realize that the right to examine a witness directly and without limitations is a fundamental right. It's one of the most important rights of the defense. It is one of the rights that are part of Article 6, paragraph 3 of the European Convention of Human Rights and 14, third paragraph of the ICCPR, which is the right to a fair trial. The right to be allowed to question incriminating witnesses, Article 6, paragraph 3 under D of the European Convention of Human Rights, is intended to allow verification of. So we now have a relatively recent judgment of the European Court of Human Rights. It's known as the Kesken judgment, and it emphasizes the importance of the right to examine. The Dutch Supreme Court has also interpreted its judgment, meaning it's now also part of the Dutch legal order. And there we see that importance too. If an incriminating statement of a witness that the defense was unable to interview is used to declare the charges proven, the court has to verify if, and if so, provide reasons for why the proceedings still comply with the right to a fair trial laid down in Article 6 of the European Convention of Human Rights. As we've said, an unrestricted and direct questioning is the starting point, and that starting point is not absolute, can be necessary for exceptions to be made. So that is possible in different ways and the different conditions. The European Court of Human Rights usually makes a distinction between witnesses that could not be questioned. They are called absent witnesses, they were not there in court, and anonymous witnesses. The way in which the defense is restricted in their right to examine differs per type of witness. If a witness could not be questioned, then the reliability of their statements can. The restrictions are of a different nature. Possibly the witness could be questioned in that case, but the person not being known, their background not being known, is the serious limitation there. Questions that could lead to the witness's identity being revealed will not have been asked, will not have been answered. In Kostovsky, the European Court of Human Rights considered the following, and I quote, "If the defense is unaware of the identity of the person it seeks to question, it may be deprived of the very particulars, enabling it to demonstrate that he or she is prejudiced, hostile, or unreliable. Testimony or other declarations inculpating an accused may well be designedly untruthful or simply erroneous, and the defense will scarcely be able to bring this to light if it lacks the information permitting it to test the author's reliability or cast doubt on his credibility. The dangers inherent in such a situation are obvious. In the Ellis, Sims and Martin judgment, European Court of Human Rights went into more detail with regards to the differences in restrictions, and I quote, "The precise limitations on the defense's ability to challenge a witness in proceedings differ in the two cases. Thus, absent witnesses present the particular problem that their accounts cannot be subjected to searching examination by defense counsel. However, their identities are known to the defense, which is therefore able to identify or investigate any motives they may have for lying. Anonymous witnesses, on the other hand, are confronted in person by defense counsel who is able to press them, at times vigorously, on any inconsistencies in their account. The judge, the jury and counsel are able to observe the witness's demeanor under questioning and, by doing so, to form a view as to their. In the case of a fully anonymous witness, where no details whatsoever are known as to the witness's identity or background, the defense faces the difficulty of being able to put to the witness, and ultimately to the jury, any reasons which the witness may have for lying. However, in practice, some disclosure takes place which provides material for cross-examination. The extent of the disclosure has an impact on the extent of the handicap under which the defense is laboring." So in that judgment, the European Court of Human Rights goes into those limitations caused by an ordinary witness not being interviewed, so that's a non-anonymous witness, and the limitations caused by the anonymous status of a witness that was interviewed. Accumulation of both limitations, as in the case of X48, who is both a non-interviewed and an anonymous witness, is so extreme that, with a few exceptions, which I'll go into, but it's so extreme that we don't often see it in case law. Since the restrictions in case of a non-questioned ordinary witness are often different than those of a questioned anonymous witness, the frameworks used for assessment are also different, and I will briefly discuss both frameworks in order to then combine them. When complaints are made to the European Court of Human Rights about a violation of the right to question incriminating witnesses, the European Court checks whether the complainant had a fair trial in the national proceedings. In its judgment in the Al-Kawaya and Tayari case, the European Court of Human Rights introduced the three-step test, which has been used consistently ever since in order to check whether the right to examine was sufficiently respected. The use of that three-step test makes it possible to include all relevant facts and circumstances in assessing the fairness of proceedings, so the overall fairness. And the starting point of the three-step test is that the defense was offered no proper and effective opportunity to question a witness, in spite of the defense wanting to question that witness. The steps are the following. First of all, was there a good reason why the witness could not be questioned properly and effectively by the defense? Secondly, is the sentence based exclusively or to a decisive extent on the statement of the witness not questioned by the defense? And thirdly, was any compensation offered for the impossibility of verifying the reliability of the witness? So, as I've said, the type of limitations with anonymous witnesses are different from those with witnesses that have not been questioned, but they have in common that the defense was restricted in investigating the reliability of the statements previously given by the witness. So with regards to anonymous witness who have been questioned, in substance the same approach is taken as with regards to non-interviewed witnesses. Since Ellis, Sims and Martin, that other judgment of the European Court of Human Rights, a variation on the three steps model that I've just described is applied in order to assess whether a conviction based on anonymous witness statements is in line with the right to a fair trial. The questions are the following. First of all, was there a good reason for concealing the identity of the witness from the defense? Secondly, was the conviction based exclusively or to a decisive extent on one or more anonymous witness statements? And thirdly, was compensation offered for the limitation which, not knowing the identity of the witness, constituted for the defense? So the applicability and the specifics of that three-step test in anonymous witnesses was later confirmed in other judgment, including in the Suleiman judgment. That judgment shows that in case of an accumulation of limitations, so in case of an anonymous witness that could not be questioned, that then there's a four-step test that needs to be applied. And I have them written down here, but to summarize, those are the three steps I've just mentioned twice put together. So was there a good reason for not questioning, for concealing the identity in the other steps? And I will now discuss those four steps.
The first step is, was there a good reason for anonymity? Even though awarding the status of threatened witness was already really large in that respect, the defense feels that it is so fundamentally flawed that using the results of the witness interview would be at odds with the right to fair trial. And in that case, should that come up, according to the Supreme Court, there should be a review, a possible review, with respect to the prerequisites for granting such a status on the part of the bench. I will explain what the fundamental flaws are concerning the anonymous status of witness X48. Restricting the rights of the defense, such as not disclosing the identity of a witness, for that there needs to be a relevant reason and a sufficient reason. Relevant reason with respect to anonymous witnesses is a reason that can justify awarding and maintaining anonymity in general. In the ECHR case law, there are two reasons that can justify anonymity, being protecting the well-being of the witness, this is the fear for retaliation, and also the interest of deploying a police officer or an informant in the future. Anonymity can only be granted if there is specific facts and circumstances on the basis of which one can assume that two of these grounds, because the third ground was really very irrelevant for this case. So that can only be done if there are specific reasons on the basis of which one can assume that one of these grounds is applicable. In that case, there is sufficient reason for anonymity. Anonymity may not be granted lightly. This decision to award anonymity must be considered to be a measure of last resort. With respect to X48, the only conceivable ground for anonymity is the fear for retaliation. Such a fear is not always sufficient to grant anonymity. In Al-Kawaja, the ECHR considered the following. This does not mean, however, that any subjective fear of the witness will suffice. The trial court must conduct appropriate inquiries to determine first whether or not there are objective grounds for that fear, and second, whether those objective grounds are supported by evidence. This consideration, in short, boils down to the following, that the simple subjective fear is insufficient to grant anonymity. The fear has to have an objective basis in facts and circumstances, and these facts and circumstances need to be demonstrated. In Suleiman, the ECHR confirms as much. According to this judgment, awarding anonymity requires an individualized assessment taking account of the particular circumstances of a given case. If there is no substantiation as to why, with respect to this specific witness, there's an actual danger regarding his well-being, assuming that there's a justified fear for retaliation, we award anonymity. And obviously, simply referring to the legal ground for awarding anonymity is insufficient. And also the simple fact that the witness has made a statement about the involvement of a suspect in a serious crime, as such, is insufficient ground for anonymity. I have the references of the judgments putting forward these positions in the footnotes. Furthermore, we have the principle of subsidiarity. If it is possible to protect the well-being of a witness, so even if there is such a sufficient reason, and it is possible to do so in a less invasive way than by granting anonymity, that should be chosen. So if awarding anonymity is justified, the question still arises, which measures are considered to be necessary to safeguard anonymity? For instance, will only the name of the witness be redacted, or also the background of this witness? And if I apply this to what happened with X48, I see the following. The investigating judge has decided that X48 can be given the status of threatened witness and has considered, and I'm quoting, it becomes apparent from the facts and circumstances in the official report, the context as described in the applications of the prosecution. It becomes apparent from the offences the defendant is suspected of, and also information from witness X45 to the investigating judge regarding his personal circumstances as referred to in Article 226A Code of Criminal Procedure. One cannot infer from this that the threats are, as referred to earlier on, that are by nature specific and serious in order to justify the anonymity of a witness, and also a serious infringement of a fundamental right for the defense. First of all, the investigating judge wrongly involved offences the suspect may be suspected of. In any case, that is not a relevant reason. Also, if we look at the legislative history of the Act Witness Protection, we read that the seriousness of the offence the suspect is suspected of, that be the basis for prosecution, and that question should be disregarded. Furthermore, the investigating judge wrongly did not make a choice between the kinds of threat that are being feared, nor who we should reasonably assume should consider to be threatened, or what the fears are specifically, because only the legal criterion was copied, and the investigating judge has not disclosed the basis for that fear. The investigating judge says that there are relevant reasons, but does not specify which ones, let alone that they would be sufficient. And furthermore, the grounds referred to by the investigating judge cannot support this decision. There is reference, for instance, to the offences and the facts and circumstances set out in the criminal file without specifying that, whereas the case file contains more than 60,000 pages now, and we do not know exactly what was in the case file on 15 January 2016. And also the context as set out in the application of the public prosecutor that the investigating judge refers to cannot serve to substantiate or explain the necessary threat in the meaning of Article 226A of the Code of Criminal Procedure. The public prosecutor's application only sets out that the witness and or others can consider themselves threatened, and that fear or threat can become apparent from the nature of the crime and the geographic and political context in which all this transpired, which context can entail risks for retaliation for anybody who makes an incriminating statement. So, in other words, there could be a fear for unspecified retaliation on the part of unspecified persons or groups. So who would consider such retaliation? What kind of retaliation would be, or whether this fear is justified or not, that has not been substantiated in any way. In any case, this threat does not appear from the reports and official records and other documents the public prosecution refers to at a later stage in connection with other anonymous witnesses in order to substantiate this required threat. All these other documents that I just referred to have not been put forward with respect to X48. These letters and other documents, as far as we know, were not yet part of the criminal file that the investigating judge refers to when the decision was taken concerning the status of the witness. And in my footnote, I have included all the dates of all these documents, showing that they are from a later date than 2016, always 2018 and later. So they cannot have served as a basis for the decision in connection with X48. Something else that doesn't become apparent in any way is that non-disclosure of everything would be required, i.e. more than only the name. Why would it be necessary to decide not to disclose all the information on the background of X48? We cannot infer from the decision of the investigating judge that there would be more than a general, unsubstantiated fear for unknown, unspecified implications, whereas it's not clear whether these implications would be more or any different than in the case of nuisance or anything else that would be unpleasant. So what has been put forward in the decision, including the application of the public prosecution, simply cannot justify the granting of this status. The relevant and sufficient reasons have not become apparent, and the principle of subsidiarity has not been fulfilled. If this were not the case, then any witness that could make an incriminating statement about a crime in an unspecified geographic and political context, and there's always a context, that would allow not disclosing the identity and background. That would apply to any witness who can make an incriminating statement within a certain context. In the case at hand, that would be every incriminating witness, and that is in contravention with the purpose and the nature of the arrangement set out in Article 226A, Code of Criminal Procedure, and Article 6 of the ECHR. This was step one. Step two is there good reason not to offer the opportunity to question? So now we're not talking about the status of anonymity, but the reason why he could not be questioned. And for this decision, there needs to be both a relevant and a sufficient reason. And just as with respect to awarding anonymity, the simple subjective fear is insufficient not to offer an opportunity to question, and this fear has to be made plausible. And I'd like to refer to what I have just explained. If the witness is granted the status of anonymous threatened witness, that does not automatically imply that he cannot be questioned. The authorities will have to ask themselves ex officio whether the witness can be questioned in such a way that the identity of the witness is not disclosed. And that specifically could be, for instance, a direct questioning in which the witness is not visible or is disguised, or in which a voice transformer is used. That would be a limited anonymous witness, or questions could be submitted in writing, and the questions could be raised by the investigating judge, or the questions could be submitted to the witness, and the witness could answer those questions in writing. So if it is important not to reveal the identity of a witness, then the least invasive method should be chosen, and the judgment will show whether these alternative methods to question the witness were considered, and why it was considered necessary to deprive the defense of every possibility to question the witness. Now, if I apply this context to X48, first of all, I shall highlight, for the sake of clarity, that the witness was not able to question X48. No reason, let alone a good reason, no reason has been put forward for setting aside this possibility to question the witness from the moment in which the name of the defendant was known, and that was at the latest 25 October 2016, up to the moment in which it became apparent that it wouldn't be possible to question the witness. This was early 2021. So there was no such reason, not a good reason, but no such reason not to deprive us of the opportunity to question the witness. There was no such reason. Implicitly, a reason may be derived for the decision not to give the defendant the opportunity to raise questions. So implicitly, a reason can be inferred from the official report of 29 January 2019. Here we're talking about more than 2 years after the identity of the defendant had been disclosed. In this decision of 29 January 2019, we read that the public prosecution, in connection with other witnesses, so not in connection with X48, so we read there that the public prosecution has requested the investigating judge in connection with other witnesses not to allow the defendant to ask any questions in this stage and not to proceed to serve the order granting the status to the defendant. So in connection with other anonymous witnesses, the investigating judge was asked not to inform the defendant. Perhaps the investigating judge, for that reason, also decided not to give our client the opportunity to use his right, which is set out in imperative rules, to question the witness in connection with X48. If that was the reason, in any case, it's not a good reason to set aside this opportunity to question. If the public prosecution is considering a suspect and does not want the suspect to be informed thereof, then the public prosecution must not make an application pursuant to Article 226A, Code of Civil Procedure, Criminal Procedure, which requires that a suspect be informed and requires that a suspect be given the opportunity to raise questions to the witness. It is up to the investigating judge to supervise this process, and as soon as it was possible, that means as soon as my client's name had been disclosed, which was 25 October 2016, from that moment onwards, the investigating judge should have served him the status order and should have given him the opportunity to have X48 questioned. Furthermore, on 19 June 2019, the public prosecution disclosed the name and the photograph of our client and did so publicly as a defendant. The apparent desire of the public prosecution to leave our client in the dark could not have been a real reason, not even a bad reason, not to allow client to question X45. In its decision on 3 July 2020, the court instructed the investigating judge to make sure that X48 be questioned. In order to implement this instruction, the defendant requested to submit questions, written questions. So on 5 October, the defense could submit a question, and the defense, in its letter on 5 October 2020, also explicitly emphasized how important it was to ask X48 questions directly and in an unlimited way, particularly now that underlying documents are being withheld, and it was not possible to assess the reliability of the value of X48. On 26 January 2021, the investigating judge informed the defense that it was not possible to question witness X45 within an acceptable period of time. And in the official report, we read the following. In the unredacted letter of 21 January 2021, the public prosecutor informed the investigating judge on the possibilities and impossibilities of organizing an interview of the witness. The investigating judge cannot comment on the information received from the prosecution because that information can lead to revealing the identity of the witness. Public prosecutor advised not to go ahead with the interview of the witness. In this advice, the public prosecutor considered all the ways in which such a possible interview could take place: in person, via video connection, several occasions. None of these interview methods, according to the prosecution, can be carried out with sufficient safeguards for the safety of the witness. The investigating judge believes that an interview of the witness, for practical reasons and also for reasons of protecting the identity of the witness and protecting his safety, cannot be organized, and the investigating judge, under these circumstances, cannot carry out the referral of the court and the instruction to once again interview X48. In short, the defense cannot and shall not question X48 because the investigating judge, based on the advice of the prosecution, believes that this is impossible. We can only guess why this is not possible. Nothing is stipulated in the documents provided to the defense, not even if these are reasons of a practical nature or reasons concerning the protection of the identity. Even this is an and/or situation. The letter doesn't say why it wouldn't be possible to ask questions in writing. This possibility with potentially a moderate compensating effect, I'll discuss that later on, this possibility doesn't even seem to have been considered. So in short, there are no relevant or sufficient reasons for not proceeding to offer the defense a possibility to examine the witnesses. Step 3 of the decision model, which is the question, are the testimonies decisive? First of all, case law with the European Court of Human Rights. A testimony is decisive if it determines the outcome of a case, in the sense that the chances of conviction would be much smaller if the testimony would not be used as evidence. A testimony that is indispensable, in the sense that without such a statement, the suspect would have to be acquitted, is almost always of decisive significance. And the decisiveness of testimony is often assessed by looking into the support that such a testimony can provide. Corroborating evidence can only affect the decisiveness of a testimony if it concerns matters disputed by the suspect. And these are precisely aspects on which the defense would have liked to question the witness. And furthermore, not any type of evidence that corroborates disputed topics can be used as corroborative evidence. Insufficient as corroborating evidence is, for instance, the statement of another witness that could not be questioned either. And furthermore, the quality of corroborating evidence and the amount of corroborating evidence seem to be important factors. And it can also be relevant that there be a specific reason to doubt the reliability of the testimony. In that case, more corroborating evidence must be available. If we apply this to X48, first of all, the conclusion is that X48 is decisive. I've already explained this in connection with Article 344A, Code of Criminal Procedure. In summary, because without X48 there is nothing more than, even if we were able to establish that, than that in and or by members of the DPR, a book tailor would have been transported on the one hand, and that MH17, even if that could be established, was downed by a book missile on the other hand. And the link between these two events cannot be made without X48, because that way there is nothing that would show that MH17 would have been downed by that DPR missile. Without X48, there is nothing that could show the alleged involvement of our client with respect to the missile that would be linked to downing MH17. The witnesses and the statements of X48, therefore, are decisive for the outcome of the case, decisive in the sense of the case law as discussed at the ECHR.
The second point relating to the step 3 is the question about corroborating evidence and the decisiveness of the witness statements by X48 cannot be undermined by corroborating evidence put forward or available. Everything argued as supporting X48, unlike what the prosecution is asserting, does not align clearly with X48. Most statements argued, and as well the facts and circumstances, are even inconsistent with X48. A single smoke plume witness statement might corroborate X48, but those are statements by witnesses interviewed by the SBO, which the defense, despite request to this effect, was not allowed to examine, and for this reason they are not usable as corroborating evidence in the sense of the ECHR. Also in connection with the track marks discussed by the prosecution, the most striking track marks and the black edge around the field, they do not corroborate X48, because what X48 stated about the alleged launch site does not correspond with track marks, and the alleged plowing does not correspond with the black edge either. I explained that. What the prosecution explicitly argues to corroborate X48 is therefore not corroborating. In addition, the value of this alleged corroboration is nil. At most, it concerns something that could be used to say that on 17 July 2014, somewhere south of Schiphol, there was a vapor or smoke trail, and that on 16, 17, 18, 19, or 20 July, there was a fire on the field near Perfumaisky, and that both before and during that period, Caterpillar track vehicles drove around there. But this is very far removed from the offense charged, nor does this have any distinctive value, because in that period, in that area, smoke plumes, fire, and track marks were commonplace. So what was argued, even if it relates to X48, it cannot be considered corroboration of any value. Moreover, what the prosecution put forward does not concern section disputed by the defense, and that's what ECHR is about. Conceivably, there was a smoke plume, there may have been fire, and track marks may have been formed in the period between 15 and 21 July 2014. That's not the question here. It's not even remotely close to the question here. It doesn't matter whether there was a fire on the field or whether Caterpillar track vehicles drove around there. What matters is that on that field, what matters is whether the missile that hit MH17 was launched from that field. And this section is not corroborated by what the prosecution puts forward, not even if what is argued closely corroborates X48. Moreover, the prosecution says that it's important for the defense to have investigated that, and that is not the case. We tried, but the prosecution consistently resisted this, and those requests for investigation were consistently rejected. The defense was not allowed to examine the vapor or smoke trails or statements that might theoretically corroborate X48, although extremely indirectly and hardly distinctive, but the defense was not allowed to do so despite requests to that, and the only witnesses the defense was allowed to interview in connection with the smoke plume were S40 and S20. The interview by the defense of S20 then revealed that he had not seen a smoke trail, unlike the suggestion that appears evident from his JIT interview. He did not know either whether somebody else had seen that. So S20, one of the two witnesses who could be interviewed, turns out not to provide any corroboration at all. The same holds true for S40. The other witness relating to this smoke trail that the defense was allowed to examine, it appears that he says that it was at a different location. He drew it at a different location than the one referred to by the charges and presented to X48, and that's the location where X48 put in a mark on the map. So the only two witnesses that could be investigated in more detail turn out not to corroborate X48 at all. On the contrary, nor was the defense allowed to examine the image analyst and his findings, and the same holds true for the defense experts, the drafter of the KNMI and ESA reports, whose conclusions the prosecution put forward to corroborate the track marks and plowing marks, but the defense was not allowed to question them despite repeated requests. So the defense asked to examine witnesses to investigate all investigation results mentioned by the prosecution. Based on the interviews of the only two witnesses that could be interviewed, it turns out that they are not corroborating evidence for X48, and the defense, based in part on the objections by the prosecution, the defense was not allowed to question the other witnesses. Now let's see which section I am at. Okay, this was the last section of step 3, and that concerns if you do attribute corroboration to the question as to whether X48 is decisive, it might matter whether there are questions about the reliability of the statement by X48. And if there are such questions, then additional corroboration is needed. The reliability of the witness statement by X48 does raise many questions. The fact that he varied his statements about the numbers of persons said to be there, the times that he was there, as well as him saying first that there was one and then there was no missile, are reasons to doubt his credibility. In addition, X48 apparently needs to remain so anonymous that he cannot even be interviewed, and that is intrinsically a reason for doubt. If he was, in quotation marks, just a passerby, so a coincidental passerby, then it's impossible to see why X48 cannot be interviewed in any way. Apparently there's something unusual about him, more unusual than there was about M58, S40, or other persons who said that they fought on the side of the DPR and could be questioned in limited measure. I will deal more extensively with the specific circumstances raising questions about the reliability later on when I discuss counterindications for reliability. That's another point. Here I will make do by stating that there are sufficient reasons to doubt the reliability, and that's why more corroborating evidence than otherwise is necessary to eliminate the decisive nature of X48. For lack of relevant corroborating evidence, this decisiveness may therefore not be questioned. You've been speaking for nearly an hour, perhaps. Do you plan to complete this chapter 4 before lunch? That is nearly page 160. Quite honestly, I forgot to think about what I would complete before the break in advance. I'm checking over here. I've compared this with the page numbers. Sorry to distract you. No, that's okay. So at around 106, you'll be through a substantial section, but if you say you want to complete that before the lunch, 1/4 over there. If you were to stop at 106, then you've covered 1/4. It doesn't really matter, but if you want to complete chapter 4 before lunch, then perhaps you'll have to add something. Well, if step 4 is 1 page, when I've covered that, that takes me to the question about compensation. That's quite a substantial section. Let me see whether I could do that all in one go. Compensating. We could also just insert a short break now. Okay, let me finish one more page. Of course not. That's all step 4. That's good. Then I'll check how far I can get before lunch. Shall we have a 20-minute break? We'll continue at 11:20. Yeah, it may be a bit sudden, but you're right. Step 4 is a very long part. All rise. Please be seated. Court is now in session again. Mrs. ten Doetsrade, thank you. Before I resume, I intended to draft a chart of what I would present when, because it's quite complex, but now I saw, that's why I was a bit confused in leafing through the table of contents, ends after 3 of the headings, so that complicates determining where I am based on the table of contents. Whereas everybody listening to this would appreciate being able to have an impression. So during the break, my office associate revamped the headings, so the table of contents is more detailed. One of the ushers is now printing that out, and as soon as it's available, it will be given to me, and I'll be able to share it with you, and then we can keep checking where we are. And it will be included online as well in my digital version, but it's also convenient for me to know where I am, as well as for everybody who's listening. The ECHR says that if a witness cannot be questioned and is anonymous, there are 4 steps to assess whether various consequences can be associated with that. I have covered the first 3 steps. Now I'm at the 4th step, which is the question as to whether compensation has been offered. And let me jump in again. Yes, back to my text. That takes me to paragraph 263 for the clerk and the interpreter. If a witness is testified anonymously, the defense, for lack of knowing the witness as a person, that's why compensation needs to be offered, and compensating factors make it possible to assess the reliability of the witness statement after all. The specific factors that are effective depend on the type of restriction. In the considerations of the ECHR on this topic, 4 aspects are identifiable. 1, compensating factors that allow investigation of the reliability of the witness or the witness statement. 2, counterindications, factors indicating that the unreliability of the witness statement. 3, omission by the judicial authorities, i.e. the authorities refrained from potentially compensating measures. And 4, omission on the part of the defense. Below, I will discuss the factors that need to be considered in the question about compensation as far as they relate to X48. Until the break, I'm deviating from my text now, until the break, I believe I can cover the first and the second of these 4 aspects in step 4. I've checked whether I would succeed covering all of them, but I think that will be too ambitious. So when I consider factor 1 in terms of the question about compensating the counter indications, I propose we break for lunch after I've covered that, and that would be on page 142. Now, back to the text in my pleading notes, and that takes me to the question, are there compensating measures with respect to X48? That's the first aspect of step 4. And I wondered what could potentially be seen as a compensating measure in this case. The first bit I will discuss concerns the 226A through F procedure, which deliberately appears with a question mark. The necessity for compensating measures, if we're talking about anonymous witnesses, has been acknowledged in Dutch law. Lawmakers have explicitly opted that for not categorically declining anonymous witness statements, but nonetheless to subject them to rigid conditions. Lawmakers aim through this procedure to respect fundamental rights and interests of defendants and witnesses wherever possible, and to weigh conflicting rights and obligations as carefully as possible in compliance with the ECHR case law prevailing at that time. And the exception to anonymity is possible only if the judicial procedure contains sufficient safeguards to provide sufficient counterweight. The lawmakers considered such a procedure does not mean that there is no restriction to the right of the defense to question the witness, but that restriction, because of this procedure, is no longer such as to violate the provision of ECHR 6. In the law of 11 November 1993, the Protection of Witnesses Act, the 226A through F Code of Criminal Procedure, was introduced and embedded in Dutch law. This procedure requires strict adherence to compensate for the coinciding curtailment of the right of the defense to direct and unrestricted questioning of the threatened witness for the prosecution. The restriction may then no longer constitute a violation of the right to a fair trial. So it requires very strict adherence. This procedure requires strict adherence. May, because the provisions of 226A through F Code of Criminal Procedure comprise minimum safeguards. The lawmakers have explicitly stated that they believe that the provisions in 226A through F Code of Criminal Procedure meet the requirements formulated at the time by the ECHR and the Supreme Court, but that this does not mean that adhering to this arrangement will be sufficient in all cases to meet the requirements of ECHR 6. Every procedure in the proposed arrangement shall need to be reviewed according to the provision in this convention. Also, it will need to be reviewed according to 226A provision as well as ECHR 6 to determine the fairness of the procedure overall in light of the rights guaranteed under ECHR 6, including the right to an independent impartial court, as well as the ECHR guarantee of an actual remedy. The court had the opportunity and even the obligation, if such arises from the ECHR case law, to set additional requirements complementary to 226A's provision. And all of this makes clear that the conditions of 226A and beyond are an absolute minimum threshold for the admissibility of incriminating evidence of an entirely anonymous witness. To constitute compensation, these conditions must at least be strictly adhered to so that the coinciding right of the from also violating the right to a fair trial, and the court will need to assess this separately in each case. This rigidity is not surprising given the special nature of the arrangement, the underlying problem of conflicting human rights and fundamental interests, and the inevitable infringement on one of the most fundamental rights of the defense in applying this arrangement. In the Koch versus the Netherlands ruling, the ECHR confirmed once again that the 226A procedure, if structured with care, sufficiently respects the rights of the defense. In other words, only if that procedure has been structured with care may, through that procedure, the sufficient compensation be provided for the right to interview a witness without restriction and directly, so that there is no violation of ECHR 6. This minimal compensation in keeping with the 226A procedure has not been met. On the contrary, it has been blatantly disregarded. Client has not been given the opportunity to question X48, and the investigating judge checked the reliability of the threatened witness based on insufficient and incorrect means, and therefore the assessment of the reliability is factually incorrect, incomprehensible, incomplete, since providing an opportunity to ask questions in the investigation of a judge into the reliability of the witness have also been mentioned by ECHR as measures for compensating effect. I will address these individually, so not in discussing the 226A procedure, but I will zero in on them and discuss them as separate chapter because the ECHR also mentions possible additional compensating measures. What I will discuss here is what else went wrong in the 226A procedure. Plus another step. Something else went wrong in that context, and I will discuss that as well in connection with still another part of Step 4. So that's the part of Step 4 that is not the first but the third factor, which is the omission by the judicial authorities. And that's stated specifically by the ACHR, but relates to the 226A procedure, and I'm going to zero in on that separately as well. In connection with the section of Step 4 that I'm discussing now, which is the question as to whether the 226A procedure may intrinsically and entirely be regarded as a compensating effect measure. What matters, since it has not been implemented strictly and completely, that cannot be the case here. That's my table of contents. Okay, that is more informative. Thank you. Now, let's see. Moving on. Yes. Very well. That takes me to the question as to whether an opportunity to ask questions is one of the compensating measures in connection with the question about compensation. Regarding anonymous witnesses, the ECHR has attributed compensating effect to questioning the witness by the defense. This is not just any compensating factor. In fact, it carries great weight in the case of anonymous witnesses. If no opportunity to ask questions has been offered, the ECHR, referring to case law from the footnote, the ECHR will not easily assume that sufficient compensation has been provided. Had the defense been able to question the witness, then not every opportunity to ask questions will provide the same amount of compensation. The most compensating type of questioning is questioning in court, in which presumably measures are taken to avert the witness from being recognized. Other types of questioning may provide compensation. In the door zone case, counsel for the defense was present in the interview of anonymous witnesses by the investigating judge. In the Cook case, the defense listed questions to the investigating judge, which the investigating judge asked the witness, in which the replies were heard by the defense in a different room with a distorted voice after the investigating judge had determined that the answer provided would not reveal the identity of the witness. And the ACHR considered this to be compensating as well. When only written questions may be provided for answers by the witness, this will have a compensating effect as well. In the Scholler case, this was the main compensating factor, and the ECHR ruled that the right to a fair trial had not been violated. In other cases, it was different. The opportunity to have written questions answered by the intermediary of the investigating judge was regarded as insufficient. In Asani, the ECHR considered indeed the applicants and their lawyers were not present when these witnesses produced oral evidence before both the investigating judge and the trial judge, unlike the public prosecutor who attended both examinations. As to the possibility of putting written questions to the witnesses indirectly through the court, in the case of Shachachvili, the court stated that such a possibility represented a significant safeguard offered to the defense regarding examination of an absent witness who cannot be questioned at the trial. However, regarding anonymous witnesses, the court has also found that the nature and scope of those questions were considerably restricted by reason of the trial court's decision that the anonymity of the witness should be preserved. In the present case, the court finds that the possibility offered to the applicants to put written questions to the anonymous witnesses cannot be regarded as a sufficient procedural safeguard to counterbalance the constraints with which they were confronted in the exercise of their defense rights. In Suleiman, the ECHR was firmer and emphasized that withholding the unsated by the mere opportunity to submit questions in writing. Caution must be exercised before concluding that the possibility to put written questions to an absent witness is capable of compensating for the difficulties arising from his or her unjustified absence, that is to say, when there was no good reason for his or her non-attendance. Otherwise, the balance between the rights of the defense, the interest of the public, and the victims in seeing crime properly prosecuted, and where necessary, the rights of witnesses risk being undermined in the absence of a good reason to depart from the underlying principle pursuant to 6.3d of the Convention. So, ECHR qualifies the opportunity to ask questions as a major compensating factor that may carry a great deal of weight, but may not be sufficient in the case of anonymous witnesses such as X48. When I was discussing the second of the four steps, which was a good reason for the absence of this opportunity to ask questions, I already discussed that this potentially compensating factor was not addressed in the case of X48. X48 was not questioned by the defense and the investigating judge procedure. The question was not given the opportunity to ask questions without limitation directly nor indirectly or by remote or video connection or in writing. In the decision on 3 July 2020, the court decided that X48 was still to be interviewed, but on 26 January 2021, the investigating judge concluded that this would not be possible within an acceptable time frame. At no point was the defense therefore able to question witness X48, and this is
That is also my point, since the defense was not in no way allowed or able to otherwise investigate X48. We tried. On the 25th of August 2020, the defense asked the investigating magistrate for additional documents to summarize the more extensive records of the interviews of X48 from the reporting officers and the investigating magistrate on the 1st of August. Defense made a similar request, and the court was requested to order the sharing of all reports, records, correspondence, and documents regarding contacts with and/or statements by X48. Because the summary that was added does not make clear which parts were stated spontaneously, which parts are answers to questions, which questions were asked, and or which information was shared with X48. In order to be able to assess the succinct summary, as well as assessing the reliability of the answers of X48 in later interviews, it is necessary for the defense to get more insight into the course of defense during the aforementioned statements given to the reporting officers, as well as during any other context between X48 and the GH of the Public Prosecution Service. So that's how we substantiated that request for additional information. On the 21st of September 2020, the investigating magistrate, in response to that request, considered the following. Investigating magistrate has considered the following first and foremost. From the system of the legal arrangement regarding threatened witnesses, it follows that it is the responsibility of the investigating magistrate to conceal the identity of the threatened witness. The investigating magistrate must take all measures that are reasonably necessary for this. The information relevant to the case, to the extent it can be released in view of the threatened witness's identity being concealed, has been included in the redacted statement. To the extent there were any discrepancies or striking points in the preparatory documents, these were dealt with during the 226A process, or they are clear from the record drawn up by the investigating magistrate pursuant to Article 226E in view of the nature of the 226A process and the role of the investigating magistrate in protecting the identity of the witness. The production of further documents regarding X48 is not at issue. The court denied the defense's request for further documents on the 28th of September 2020, referring to the considerations of the investigating magistrate. In the letter of the 5th of October 2020, the defense made another attempt to persuade the investigating magistrate to provide the requested documents. And we said the following. But the prosecution service takes the position that the investigating magistrate, in applying Article 226F, has decided that the reference documents could not and should not be added. It's true that Article 226F does provide that the investigating magistrate can take measures that are reasonably necessary in order to keep the identity of the threatened witness concealed. In your response, we've read that you did assess that the contents of the reference documents, in your opinion, has been included in the redacted statement, and that disclosure, because of the protection of X48, is not at issue. However, it doesn't explicitly say that withholding the reference documents is a measure you think necessary in order to keep the witness's identity concealed. It cannot be excluded that the aforementioned consideration should be taken to mean that the investigating magistrate, in view of the contents of the redacted statement, apparently in line with the reference document, it cannot be excluded that the investigating magistrate sees no reason to provide the documents. However, that's not the same as the documents being withheld because it's necessary to protect the witness's identity. From the response of the 7th of September 2020, it is not explicitly clear whether the investigating magistrate doesn't think these documents should be disclosed because it is not relevant. It shouldn't be disclosed because there's not a good reason for that, or because it's necessary in order to protect the witness's identity. If it's the second reason, then there's nothing we can do. We understand that. But if it's the first reason, that first reason being that there's no good reason to provide these documents, then we'd like to remark that simply not seeing a good reason is not sufficient reason to apply Article 226F. So if the first reason is the reason, and if you agree with us that the application of Article 226F is not justified based on that, we ask you to instruct the Public Prosecution Service and us that it is not necessary based on Article 226F to deny inspection of the requested documents. So to deny that in full or to not add them to the documents. So just in case the documents were withheld on the incorrect grounds. We made another attempt, but we failed. The documents were withheld, in our opinion, based on grounds that don't justify that. And whatever the case may be with regards to the correctness or incorrectness of those grounds, the fact is that the defense was in no way able or allowed to check the reliability and credibility of X48, not by questioning the witness and not by investigating documents apparently available that might show more. The defense had to make do with a half-a-page summary of the JIT interviews, contrary to the Public Prosecution Service, which did have access to the underlying reports of those interviews, or at least I'm assuming that is the basis for a succinct summary. And the defense also had that 1.5-page summary of the questioning at the investigating magistrate. So in light of the above, a possibility of questioning the witness is essential. Then another factor mentioned when it comes to compensation is a reliability investigation. It's another example of a measure with a compensatory effect. So that would be a record by a court who's established the identity of the witness and questioned that witness and then giving their opinion about the reliability and credibility of the witness. In the Van Mechelen case, the European Court of Human Rights was of the opinion that these measures in and of themselves were not sufficient as compensatory factors, considering, among other things, that the statements by the anonymous witnesses had been of decisive importance. The investigating magistrate who interviewed X48 drew up a record giving her opinion on the reliability and credibility of the witness as she saw it. For many different reasons, that is not a satisfactory record. It is not even close to the investigation imagined by the European Court of Human Rights as an investigation that might have some compensatory effects. And I'll explain which flaws are shown by the opinions of the investigating magistrate when it comes to the alleged reliability of X48. And that's going to take me some time, just so you know. First of all, the position is that the reliability assessment is incorrect. The conclusion that X48 is reliable is incorrect based on the reasonings of the investigating magistrate. That's clear from the record. The 226E record starts by saying that the investigating magistrate has determined that the redacted statement is fully supported by the statements given by X48 to investigating officers and contains a fair representation of it. That is not correct. Various elements of the redacted statement are simply different from what X48 told the investigating officers according to the official record drawn up by the Public Prosecution Service. So it's simply not factually correct. For example, the time of the launch is very different in both statements. In the one statement, he mentions 4 p.m. In the other statement, he talks about it being between 1 and 2 p.m. So regardless of the question of what the meaning of these differences is in and of itself, that goes to show that the redacted statement is not fully supported. It's not the same as the report. So the factual determination of the investigating magistrate is simply incorrect, and it goes for other things as well. For example, the number of people allegedly present at the checkpoint, according to X48. According to the prosecutor, X48 told investigating officers there were 11 persons there, but according to the investigating magistrate, according to the investigating magistrate, X48 said that less than half were present there. And the investigating magistrate wrongly included this discrepancy in her reliability assessment as something that is fully supported by the statements given previously by X48. That is incomprehensible and factually incorrect, since it's not at all supported. And then there's another point with regards to the opinions of the investigating magistrate with regards to reliability. I just said it's factually incorrect, and now I will explain that it's also incomprehensible So that is regardless of the inaccuracies. We can read in the 226 record that the investigating magistrate deems X48 reliable because he shared details that could only be known to someone who was there. In other words, what is called information only known to the offender. The investigating magistrate thinks she knows that these details are correct and explains in the same paragraph why she is of that opinion. And that is because certain unspecified details correspond to information in the file from public sources. And that is a classic example of a logical fallacy. The investigating magistrate is saying X48 is reliable because he knows detail A, detail B, and he could only have known them if he were there. And that is reliable because public sources show that what he knows is correct. In other words, that is not information only known to the offender. It is information X48 could have obtained from public sources, as the investigating magistrate did too. And exactly because they are details that X48 could have gotten from public sources, just like the investigating magistrate, the alleged accuracy of that knowledge says nothing about the reliability of X48. The conclusion that X48 is reliable is certainly not supported by that consideration of the investigating magistrate. And in a similar way, we can point to the other facts described by X48, like the position on the spot that he described, from which, according to the investigating magistrate, he was able to observe what he said he observed. Again, the details fit with that, allegedly. But what details, I was wondering? Does the investigating magistrate mean the little X on the satellite photo shown to X48? Because that X could have been a wild guess. Nothing could show, certainly not in 2016 when the record was drawn up, nothing could show that X48 was right in doing that. What goes with the X? The smoke plume? It could fit with many other X's. On the JIT field, countless other fields between Snitchen and Sarmagila. Also many other plausible, fitting with many other plausible causes. Does it fit in with the black patch? That could also have been caused by many other plausible events, meaning that this accidental similarity says nothing. And there were many other black patches in other fields around, and he might just as well have marked those fields with an X. So does the investigating magistrate then mean other details? But how? How can the investigating magistrate determine that observations could have been made from a certain position and that details fit in with the situation on the ground if there's no factual information available about that situation on the ground, other than the satellite photo, which was shown to X48 during the interview? So anything the investigating magistrate can say based on the satellite photo on what could be seen from where could be said by X48 as well based on that photo. So here the investigating magistrate, via a similar fallacy, concludes that X48 is reliable. And to the extent that the alleged accuracy of X48's observations is not evidenced from public sources or satellite footage shown, the investigating magistrate can give no value judgment on their accuracy because the investigating magistrate cannot know it then. Finally, the investigating magistrate in 2018, so 2 years after the interview, adds that she involved data in the assessment of reliability of X48, and I quote, she said, "The places and times where the witness says they were on the 17th of July 2014 correspond to the data from the investigation into the data of the phone of the witness." That is what the investigating magistrate wrote. First of all, it's not clear what data was investigated. Was it transmission mast data? Did they take into account the sometimes large area within which it is possible to mast? Was there a connection with a transmission mast somewhere on that day, or on a moment closer to the moment when MH17 crashed? The record also doesn't show what the apparently available phone data was compared to. To what location? X48, of their own accord, mentioned no other place than somewhere between Schnitschne and Saramagila? Was the telephone data compared with that large area where countless people were present, or to a specific location? The latter is not to be expected, at least not in any meaningful way. We know that the location cannot be determined precisely based on that kind of data. The distance within which a transmission mast can be communicated with apparently is 35 kilometers. I refer you to a report that we'll still have to discuss, so we'll get back to that later. Just mentioning it here that apparently it is at least 35 kilometers. The distance between Pervomaisky on the one hand and Snizhnoye, Marinovka, Stepanovka, Dimitrovka and Sarmagila, so that's kind of the square of that area, is about 10 kilometers. If X-48's phone communicated with a mast within that area, and if that were to mean that he was within a radius of 35 kilometers of such a mast, that only shows that he was one of tens of thousands of people present in that area. And I say tens of thousands, because only in Snizhnoye you have about 50,000 people living there. And to what time were the phone data compared? X-48 mentioned various different times, but he told the investigating magistrate that he was at the launch between 1 and 2 p.m. If the investigating magistrate compared the time at which X-48 said he was there from between 1 and 2 p.m., it can only say something about the presence of the phone of X-48 in that area at a time well before MH17 crashed, in which case the phone data doesn't support his reliability but casts doubt about the question of whether or not X-48 could have seen the launch, alleged launch. In any case, there is no support for that. Without further information on this part of the reliability investigation by the investigating magistrate, it does not support a conclusion that these investigative results were a factor supporting the reliability of the witness. And certainly that conclusion is not understandable. Finally, the reliability investigation is incomplete. Crucial parts that should have been included, that should have been investigated, are missing. The investigating magistrate feels that X-48 is reliable, amongst other things, because there is no evidence that X-48 had an interest in not telling the truth, and that there is no evidence of any personal, political, or business interest in giving a statement. It is, first of all, incorrect that there is no evidence of personal or political interest. Explicitly say, yes, I have a personal or political interest in giving this statement, or in not speaking the truth. But that's not necessary. X-48 is someone who says that he was present at a checkpoint with soldiers of the warring parties in a war in Ukraine. And according to the JIT, a disaster occurred there for which one of the warring parties might be responsible. And certainly one of the warring parties is being held responsible by many people for it. Saying there is no evidence of certain interests in giving a statement or not speaking the truth does not show any awareness of the interests in this case and in such circumstances. It is not known in which capacity X-48 was allegedly present at the launch, but there's a good chance that he was in the area as part of one of the warring parties. Could even have been as an infiltrator of the Ukrainian forces, because in wars you get many kinds of espionage via infiltration. That is also clear from a report run by Amnesty International and Human Rights Watch about the situation in eastern Ukraine. So I'm not making that up. In both cases, X-48 admit of a certain, not necessarily truthful, nature. Another possibility is that X-48 was on the spot as part of the DPR forces, so that he was on that side of the conflict. Whether he's still on that side of the conflict, or whether he's switched sides by now, or whether he was detained by the SBU at the time or during the interview, doesn't make much of a difference for the question of whether or not he has an interest in giving a statement. Because then too, in any case, you would have a personal and political interest in giving a statement connected to this case. Just to be clear, that a witness has an interest in giving a statement or has an interest in certain contents of a statement doesn't necessarily mean that X48 or that witness is lying. But you cannot say that there is no evidence of an interest in giving a statement or in not speaking the truth. And because there is no evidence, it certainly does not support the conclusion that X48 is reliable. What the investigating magistrate should and could have done is investigate the question of whether or not certain interests seem to be playing a role for X48. We have the explanation to Article 226E, and that shows that the investigating magistrate in that regard could have investigated previous history, connection to the accused, connection to the criminal offense, and their reputation, whether X48 was ever detained with the SBU, could have looked into the question of how X48 ended up with the JIT, whether that was via the SBU. That's the kind of investigation that the European Court of Human Rights seems to attach some kind of compensatory value to. Previous history, involvement or connection to the accused, or lack of such a connection, involvement in the criminal offense, and their reputation are very important in this case, especially in connection with a witness like X48, and I'll go into this later as well when we talk about his background. The role of the SBU as well is crucial in determining whether or not X48 can be deemed reliable. So in this situation, those indispensable parts of the reliability assessment are missing. The 226E record doesn't say anything on the subject, so at the very least, the reliability assessment is incomplete. Another aspect that has wrongly not been included in the reliability assessment are the inconsistencies and demonstrable inaccuracies in X48's statement. They were not included in that reliability assessment, at least not in a negative sense. For example, the aforementioned facts that contradict earlier statements of X48, so that's the point in time, the number of persons. It also goes for the statement of X48 that after the explosion there was no other missile. I will go into this later as well. So when the 226E record was drawn up in August 2016, the investigating magistrate had not yet seen any reason to doubt the accuracy of the representation of X48 statements on that score. Those doubts, whether he said there was no further missile after the explosion, so that doubt only arose later in 2019, and I'll come back to this as well. But that part of X48's statement, when a reliability assessment was being written, that statement was still there was no further missile on the Taylor. That part is simply factually incorrect, even if we were to assume the JIT scenario. So the investigating magistrate should or could have known, based on public sources, as the well-known videos of the alleged supply and removal route of the book Chile that soon became public. It shows a Taylor with multiple missiles, so after a launch there should be 3 left, so you can't say that after a launch there's no other missile left. The investigating magistrate in the 226E record doesn't explain why those contradictions and inaccuracies were negatively involved in her assessment, or didn't change her opinion that X48 was reliable. So there was no reliability assessment to which any value could be attached.
This brings me to the chapter called Counterindications. So this is the second aspect related to compensation that can play a part. As we discussed, there can be counterindications. So there can be counterindications, and I mean factors that can point towards the lack of reliability of a witness or a statement. So these counterindications can also play a role in this question with respect to compensation. Even though we only have a total of 2 pages of X48 statement, it strikes us that it contains fundamental inconsistencies. The 2 pages that are available raise an inordinate number of questions. Questions about the substance of what X45 believes he saw exactly, and questions with respect to the reliability and credibility of X45. These factors that point towards the lack of reliability and credibility of X45 are factors that I will be discussing now. These counterindications, so one of these factors ensue, amongst other things, from his own statement. Let me start with his own statement. A couple of topics. First of all, determination of location. In the interview before the investigating judge, X48 was shown a map with one intersection, the intersection at the field that, according to the JIT, is the launch field. At that point in time, X48 had not yet described the location that he believed he was at on 17 July. He hadn't described it as near Schnitznoi, where he saw a checkpoint of the DPR. The question raised by the investigating judge after that comment is quite remarkable and perhaps even subconsciously leading. The investigating judge does not ask, as she should have done, which road. She asks whether X48 means the road between Schnitznoi and Saar-Mogila. The investigating judge undoubtedly knew that the JIT launch field was located near the road towards Saar-Mogila, but around, in, and at Schnitznoi there were an endless number of roads with checkpoints and roadblocks and command posts, not only in the direction of Saar-Mogila, and which roadblock X48 meant, and not the JIT or the prosecution, but what he exactly meant, is something the investigating judge could not have known, not even based on the summary of the prosecution, in which we read that, according to X48, it was indeed that road, but not whether this was an answer to an open question or a yes to a leading question with knowledge only the offender knows, such as, was it the road from Schnitznoi to Saar-Mogila near Pervomaisky? And to substantiate the position that this is something that we really need to take into account, that this possibility exists, that leading questions was asked. I'm referring to the interview of M58, and the leader of the investigation asked the first question. The very first question was whether he had seen the press conferences and whether it could be correct that it was near Pervomaisky. And if X48 was asked the same question in the same way, then a yes is absolutely meaningless. Whether the question was raised in a leading manner during the JIT interviews is something the defense has not been able to verify. The summarizing report of the interviews, which is everything we have, doesn't distinguish between questions and answers. And we haven't been able to ask X48 about this. And in order to consider X48's answer as somewhat reliable, the question should have put in an open way to X48. Where does X48 believe he himself was, instead of, was it such and such road? But things become even worse in the interview before the investigating judge, because the judge shows one map with one full field, one central field, full field, and that is the JIT launch field. That field had not been mentioned by X48, not even as an answer to closed or leading questions. Along the road from Schnitznoi to Saar-Mogila, there are hundreds of fields, also lots of fields in the vicinity of roadblocks and checkpoints and command posts. X48 only needed to put an X across on the map that was presented to him, and whether he would have pointed to that field should he have been shown a greater area is the question, and why he put a cross exactly there is also the question. The investigating judge didn't even ask how he knew this. And what does he mean to say with this cross? Does he mean an accurate location, or just an indication, or just that this would be the field and not specifically this specific location? That was not asked, and nor does it become apparent from the interview. The question with respect to reliability and credibility of X45 requires more information, and the information about the course of events, the intentions of X48 with the cross, the X that he put on the map, and also the limits of his knowledge. Another counterindication for his reliability, another topic, is the number of missiles prior to launch. According to the prosecutor, X48 said to investigating officers that he saw a military vehicle with a green missile on it with a white tip. The redacted record of his interview before the investigating judge doesn't show whether he still believes that there was one missile on the teller. In the official record of investigation before the investigating judge, it says that X48 stated that after explosion there was no missile left, which would imply that X48 initially saw only one missile, which apparently is what he stated to the investigating officer. And whether he made this statement once or twice to the investigating officer, this in any case is a reason for the prosecution and the JIT to doubt X48's reliability. They should have doubted that, because it's entirely different from what the public prosecution believed happened, namely a Taylor with 4 missiles on it, one of which was launched. Another point is the speed of launch. X48 stated that he saw a boat drive by, and then after about 5 or 6 minutes he heard a detonation or explosion. This is impossible if you look at how the book Taylor is operated. It also becomes apparent from the case file. The fact that X48 stated as much, at the very least, leads to doubts and questions. And also the number of missiles after launch. The number of missiles X48 believes to have seen after launch, at the very least, raises questions. As I said, according to the redacted record, he said to the investigating judge that after the explosion there was no missile left, which would mean that either that 4 missiles were launched, or that X48 saw a teller with in total 1 missile. In both cases, that doesn't support the charges. And by the way, the section that there was no missile left, according to the investigating judge, after the fact, this was not entirely correct. Rereading in November 2019 of the unredacted statement, not the official report, but the unredacted statement of the interview that took place in 2016, which was about they reached that conclusion. And this becomes apparent from the official record dated 7 November 2019 of the investigating judge that says that the section of the book, I can highlight that after the explosion there was no longer a missile left. This should have been that after the explosion there was 1 missile missing on the book. This is quite a substantial difference, a crucial difference. Either X48 believes he saw a Taylor after the explosion without missiles, or he thinks that he saw 3 missiles after the launch. That's important. His statement in the first case, even if MH17 would have been downed as described by the prosecution, even then his statement could not be accurate, nor could it be reliable. The way in which a change is applied to one official record by means of another record, I'm referring to the change applied by the investigating judge after a couple of years based on her notes in a previous official record of interview, that is at odds with the extraordinary trust that the judicial system has in official records. By extension, one has to assume, and one may assume, the correctness of an official record of interview that it has been drafted under the auspices of two investigating judges and a clerk, in which a sworn witness, after reading the statement, has persisted. In that sense, that we have to assume that what the record says the witness stated fully corresponds with what the witness stated. If nonetheless, exceptionally enough, it would appear that nonetheless there was a mistake in the official record, then that requires more than just drafting a new official record saying that the investigating judge reread the unredacted statement and that the quote in the redacted version is not correct. Not only from a formal point of view, this new official report should be disregarded, the one of 7 November 2019. Also, for substantive reasons, there are good reasons to disregard it. As I said, this redacted official record of interview, including the adjusted version, but including the part in which he says that there was no longer a missile, that was read to X48, and X48 under oath stated that he persisted in that. To put it simply, sentence by sentence, it was translated for him. He listened to that, and he pointed out that this was a correct representation of his statement. And this statement, I already said that, only consisted of a couple of sentences, just a sheet and a half of paper. This is so little that we can safely assume that everybody listened carefully. And subsequently, after possible changes were made, he then said that it was correct, that this representation was correct. And he didn't do so lightly. He said this under oath. In other words, after just having to take an oath to swear or to affirm that he was going to speak the truth, otherwise he would be committing an offense. And so there's no reason whatsoever to believe and assume that X48 didn't make a correct statement or too easily would have persisted in his statement. Why would that be the case? This persistence is something that one cannot just disregard. The investigating judge's notes with the unredacted statement, in any case, cannot be worth more than the official record. The investigating judge doesn't give any reason why we should attach more value to the unredacted version. As far as we know, this is not an official report, let alone an official report drafted by two investigating judges and a clerk, and it was not read to X48, and he didn't persist in it under oath. The official report dated 7 November 19 cannot detract from the redacted official report of interview of the witness X48. And so the conclusion is that X48 apparently stated that he would have seen that there was a launch installation with one missile prior to launch and no missile left after the launch. This raises doubts in the light of the presentation of facts according to the prosecution, so this raises doubts with respect to the reliability of X48. What also raises doubts is that X48, according to the prosecutor, would have told the investigating officers that around 16 hours 20 he was at a checkpoint. And then he says to the investigating judge that he was there around 2 p.m. And then, in answer to a question, he adds that he thinks the launch took place somewhere between 1 and 2 p.m. Fact of the matter is that MH17 was not down between 1 and 2 p.m., but more than 3 hours later. Nonetheless, this is the time that X48, in any case, believes he remembers. How can that be explained, and what is the significance thereof? Is X48 just guessing when he says that it was between 1 and 2 p.m., or does he simply not know because he doesn't have any observations of his own? Or is he just guessing because he doesn't remember anymore? In the first case, he's unreliable. In the second case, he we should take what he says with a grain of salt. In any case, it's necessary to determine how big this grain of salt should be in order to be able to assess his own memories. How can it be that X48 initially, just before that, said in his statement that it was 1620 hours? Was his memory, his recollection more accurate than when he made a statement before the investigating judge? That's not logical, because both points in time were short after each other, about a year and a half after the crash. Or did he see this time of 16 hours 20 in the news? But even then one would expect, it doesn't really say anything about his own observations in situ, and that we should doubt that and doubt his reliability in any case. One would expect him to be consistent, for him to have stated the same thing twice. Or is around 16 hours 20 not something that X48 himself would have said, or is it part of a question raised by an investigating officer? Contrary to common practice and what is stated in the rules, the official record that is a source of knowledge has not been recorded with questions and answers. The questions that undoubtedly will have been asked are not known. We do not know what questions were asked to him, and we don't know what kind of information was provided to him. So here, once again, we have to keep in mind that it's quite possible that 1620 hours is not an answer provided by X48, but is part of a question raised by the interviewing officers. Let's just cast our minds back to the interviewing techniques of the investigation leader of the JIT when he interviewed M58. I'm going to quote it again. Okay, I don't know whether you recently saw the press conference. Could it be that it was near Pervomaisky? What did you say the name was? Pervomaisky. What? Pervomaisky. Oh, yes, says the witness. That could well be. Yes, that could be. Now, extrapolating from that, chances are that the question, for instance, was, did you, by any chance, see the press conferences? Could it be that it was 16 hours 20? What time do you say? 16 hours 20. What time? 16:20. That could be. Well, if that is the case, X48 did not provide this answer himself as an answer to an open question, but it was a leading question that was asked to him. In any case, his answer means nothing or very little. The summary does not clarify what exactly was asked nor what was answered. The entire interview, or perhaps even several interviews, was summarized in a couple of sentences. And based on that summary, one cannot rule out that this is what transpired, what I just explained. And in that case, X48, therefore, himself stated that between 1 and 2 p.m. he would have observed a launch. And furthermore, he only made that statement under oath, that statement about the time. So that's the reason why we should take that at face value. And that X48 really believes that the launch was between 1 and 2 p.m. tells us something about the reliability and credibility. Without asking him, we cannot simply assume that X48 said anything different from between 1 and 2 p.m. And it seems that X48 in this respect is not reliable either. And also the number of people in situ raises questions. According to investigating officers, X48 would have said that he saw 11 people at the checkpoint and 4 soldiers at the military aircraft. Before the investigating judge, he refers to a much lower number, less than half the number of people at the checkpoint. So as compared to the 11 people he mentioned earlier on, that's a substantial difference. And this raises questions and doubts about the reliability, questions that we are unfamiliar with. The background and previous history of X48. From the available official records, we those records give us no information about his previous history, X48. His involvement in criminal offences has not even been looked into, and we see nothing about that in the available records. X48 is a witness who says that, along with other soldiers, he was present during the launch of a missile by armed groups in the context of a war. What was the capacity in which he was there? What is his involvement, directly or indirectly? Involvement with the persons who were launching the missile could be an issue. And the same applies to whether or not he had a link or relationship with the defendants, whether they were comrades in arms or not. That makes a difference. And also, as I said, the background of X-48 was not looked into, not in the sense of Article 226E, the Code of Criminal Procedure. Whereas this can be extremely important to determine the reliability of X-48. Particularly, for instance, if there would be a history that would point to involvement in a war and or a so-called ATO operation at the SBU, and the reputation of X-48. If there are indications that he has a reputation of someone who's unreliable, someone who has a very strong view on the war or have certain ideologies, that can affect reliability. If it would turn out that X-48 is the Ukraine at war blogger, then the value of his statements is quite different from a situation in which X-48 turns out to be any old civilian. But the latter, that it would be any old civilian, is not something we can simply assume in this case. And here, once again, I'd like to refer to the role of SBU. The documents available do not answer the question whether X-48 has been lawfully or unlawfully detained, whether he's been tortured or otherwise put under undue pressure to make a statement. The circumstances that were common practice at SBU were already discussed in the preface of the oral arguments. These circumstances could also have played a role with X-48. We simply don't know. But now that X-48 seems to have been part of one of the combating parties, it's not an outrageous thought. Many separatists were detained by the SBU in the context of ATO, and if X-48 is one of these persons, then his statements pursuant to 359A the Code of Criminal Procedure and Article 6 of the ECHR cannot be used as evidence. And since we don't have any information about that, the defense cannot put forward its defense in that respect. And so these circumstances are very important to determine the reliability of this witness. So we have these questions, but many more. And unlike the public prosecutor believes, here it would be too much to discuss all this in oral arguments. This is, at the end of the day, not a testimony, it's not a witness interview, it's oral arguments. But should we be able to ask questions, we would ask questions as to whether he was part of the combating parties, whether he had certain preferences in that connection, whether he saw the press conferences and the blogs, where he was on the 17th of July 2014, where exactly he was, how he knows that he was there, with whom he was there, many other questions based on the summary statement of X-48 in terms of the substance and also reliability of X-48.
And then there are also counterindications that are relevant for the question about compensation. These counterindications arise from the procedure applied. So some sections were excluded from the redacted report. Previously, I mentioned that the report on what X-48 appears to have stated as provided to the defense is extremely brief. The selection there can hardly be investigated because we don't know what has not been presented, except for one part, that one section that remains redacted by the investigation was brought to the attention of the defense unintentionally. The investigating judge involved in the procedure had redacted one section of the statement concerning the exact number that he believed was present at the checkpoint. That had been redacted to preserve the anonymity of a threatened witness. At one place in the redacted report, at one point, that line in the redacted report reached the attention of the defense, and at the request of the investigating judge, we did destroy that unredacted section, but that was not before the defense and before this request was made had taken note of it. And that knowledge did not disappear when the report was destroyed. So, therefore, I will not specify the redacted line in this trial. The literal text of that line appears in Annex 3, which is not part of the versions distributed to anybody besides the court and the prosecution. I do not believe that your court has any reason to question its accuracy, but to err on the side of caution. I note that the prosecution is also familiar with the version of the report that reveals the redacted text. So if the quotation is not entirely correct, we need to inform your court that the defense is making this known to the court. The covered line concerns a remark by X48 about the number of persons present at the checkpoint. I mentioned earlier that he mentioned a totally different number to the investigating judge, and that's the reason why it's important information that counterindicates his reliability based on his own statements. It's impossible to see how covering up that number is reasonably necessary to safeguard the anonymity, which is the reason given, especially since the number of 11 persons mentioned previously to the JIT by X48 apparently did not need to be redacted. Ordinarily, and this has happened a lot in this case, it would be absolutely impossible to control in any way how the investigating judge selects which information does and does not, despite being relevant, as an exception to the to safeguarding the anonymity, is not brought to the knowledge of defense. So we have no idea which relevant information is being redacted. This single mistaken and coincidental glimpse in this connection is basically a silver lining and reveals that in any case one section was covered up, even though the need cannot reasonably be understood. This inspires little confidence in the accuracy of how the rest of the selection was performed by the investigating judge, and that's relevant especially since in connection with X48 quite a bit, except for 2 pages, has not been brought to the attention of the defense. Which other inconsistencies were not brought to our attention? Which other incomplete aspects or inaccuracies is the judgment by the investigating judge as to reliability based on? Now, the next point, the sections in the redacted report that are incomplete. The reports provided to the defense are not only exceptionally limited, but they are also questionable as to whether they are accurate and complete. And I'm talking the summary by the prosecution of the redacted report from the investigating judge is in any case not complete, not even the part brought to the attention by the defense. These are very concise summaries, nor are they literal renditions of what was said in the interviews or conversations with X48. So, for example, the questions in the JIT summary do not appear. In addition, the reports are in all cases translations of what X48 said as partial summary. So we don't have a rendition of what X48 originally said. So there's a lot of clutter and interpretation problems that arise. In addition to certain sections of what X48 stated being missing from the reports or being heavily summarized, the redacted report by the investigating judge has explicit flaws. 3/4 of the first substantive page reads, "Remarks from the investigating judge. The above was stated extensively and without interruptions by the witness. We cannot assess how extensively the witness spoke, but we can assess whether or not it was without interruptions, because the same text listed above reveals that the witness was interrupted at least once by the investigation. For example, you ask whether I mean the through road between Snizhny and Sarah Megillah. I don't mean that the witnesses should not have been interrupted, but that's not. But I mean that it's simply not true that the witness stated the above without interruption. So the redacted report is simply not correct, and even the investigating judge doubted the accuracy of the redacted report. She adjusted it based on her own notes without presenting it to the witness asking about the accuracy. Both the fact that there is at least one striking inaccuracy in the redacted report and the fact that the investigating judge apparently needed little to doubt its accuracy, that intrinsically inspires little confidence as to the accuracy of the redacted report, and that the only available reports leave too much information omitted, even in parts that are incomplete, and there's reason to question their accuracy. That renders the necessity for the defense to question the witness and conduct additional investigation as to the reliability and credibility of the witness. That makes this need all the greater. I have one more page, a page and a half, and that still relates to counterindications. That's where I was. The second factor of the fourth question, counterindications arising from the actual case. And there are counterindications separate from the apparent content of X48 statements and separate from how this content was recorded, justify additional caution with respect to the reliability of every witness, including X48. After all, there is an exceptional abundance of unreliable witness in connection with this case. There's so many people who think or say that they know what happened on 17 July 2014. The file alone contains statements from people who stated that they saw the launch, while they mentioned different locations for that. People who say that they saw different causes, from launch to attack by a fighter jet or something else. And then there's the internet and other publications. Books have been written about this by now. All these people think they know for certain or say that they know for certain what happened, even though a great number of different and contradictory causes have been reviewed. There must have been only one, so a great number of these people apparently does not know what was actually the case. It's after all a fact that people make mistakes or even make things up, and this holds true not only for the people who indicate that it went differently from what the JIT thinks, or people dismissed as conspiracy-minded. It also holds true for people who indicate that the course of events was as the JIT thinks it was. That they can also include people who believe or claim that they know how things went, but that do not truly know or have made a mistake or were pressured to make the statement that they did. In any case, we do not have information revealing that the above does not hold true for X48. We do not even know whether he reached unacceptable pressure. We don't know whether he was detained prior to or while making a statement. We don't know whether he was free to make a statement or whether he wanted to make a truthful statement. And that reality, that the possibility to be able to make a free statement cannot be taken for granted, is also the reality that surrounded and may still surround witness X48. After this, I will continue with the following step in the question about compensation, which is a mission by the judicial authorities. Very good. We will adjourn for lunch. It is nearly a quarter to 2. So, excuse me, it's nearly a quarter to 1. We will adjourn until 1:30. Before we adjourn, because you just mentioned a point in Annex 3 that you wanted to submit, we don't have that. Could you please hold on to that, because I'd like to discuss that with my fellow judges. And we'd also like to state our view on that. That's one of the points I wanted to discuss, so we'll discuss that in chambers, and you can think about that, but I propose that we address that after lunch. Very well. All rise. Please be seated. I was about to start by saying that the court is in session again, but that's not what you're referring to. Before I give you the floor, I will tell you what our chambers yielded, which is that we ask that any annexes that are not submitted to the court, because then a piece of text that the court was to be decided was to be redacted should remain redacted and should not be brought to the attention of the parties. First, I'd like to hear what the prosecution has to say about that. Are you able to respond to that now? We can respond to that. I'd like to touch on 3 points. First, a question to the defense, which is whether the sentence concerned has also been shared with your client, Mr. Pulatov. I see you nodding, but that's probably not the answer to my question. No, it was not shared with Mr. Pulatov. That's comforting. That was the second point I wanted to make. What's not comforting is how the defense is dealing with due process, because this is being raised in court, and the investigating judge is responsible for procedure related to witnesses, and the defense was supposed to contact the investigating judge because, if necessary, the investigating judge can take measures to ensure the safety of witnesses, because the defense needs to consider that interest as well. The defense cannot simply go to town with the procedure that the investigating judge is responsible for. That takes me to my third point, which is exactly what you said. 226F of the Code of Criminal Procedure stipulates that the investigating judge is the only party responsible for the content of the report, including the redacted report at issue today, and is therefore the only one to determine whether a line is redacted. And the defense is very well aware of the procedure, because this is also clear from the pleading notes. They say the defense has taken note of one part that was and has been covered up, redacted by the investigating judge. And it is indeed the investigating judge who is solely responsible for this procedure, which means that it is at odds with the law if your court or the prosecution or somebody else were to take note of what the investigating judge has redacted. So that's the main reason why why that annex should not be added to the pleading notes, because this should not be disclosed. To that extent, we agree with the decision by the court. Mrs. Tandusgat, I would like to respond to that. First of all, contrary to the law, if somebody takes note of that, let me be very clear, it was not our choice to take note of it. It was suddenly there. We read it, and then it turned out that that was not the intention. We were not aware of that at all before then. So that it has been disclosed to us was not an active decision on our part to take note of it. The second point, I believe this is clear, but to avert any misunderstandings on this topic, the item that I had here was not the non-redacted report. It was simply one line written out based on what I had in my mind about that. Second, the interest of safety. I don't want any misunderstandings at all about that, which is why we can vehemently deny whether it was shared with anybody, not just not with client, it was not shared with anybody. It has not been. Of course, we are not going to compromise safety. Even if we were to disagree with this decision, we understand that if safety is a reason for anybody, and apparently has been a reason for somebody, we're not going to treat that lightly. That's exactly why we did not share it with anybody, and that's why, contrary to what the prosecution is suggesting, the point where it's not necessary to contact the investigating judge for our point here today. If we wanted to share it with somebody other than the parties we intended, i.e. your court and the prosecution, that would require a prior decision by the investigating judge, but that's not what we intended to do. We thought long and hard about this and consulted many people as to how to deal with the fact that we had that knowledge and that it's relevant to this case. The outcome was that, in our view, it's the most above-board way and a way that will not jeopardize any safety, that we do not disclose it, that we do not read it out in court, that we do not include it in our pleading notes, but only provide it as an annex to your court and the prosecution. And I would like to explain why safety would not be jeopardized in any way in that manner. So first, the prosecution already knows about it. So distributing that sentence to the prosecution already had that unredacted report. So, and we already know about it too, so that won't jeopardize safety either. The only party to learn more by distributing this would be your court. The reason your court was not allowed to take note of that redacted sentence has nothing to do with safety. It's because your court is not allowed to receive more information than the parties to the trial do. So if your court were to know and we did not, and that's what safety requires, you would have an edge on us in terms of knowledge, and based on law, that's not allowed. That's why the responsibility is the investigating judge's and not yours. That's why the investigating judge, in lieu of the court, takes note of this so that the court is not encumbered by knowledge beyond what may be included in the case. And I don't think that anybody, the court takes note of it as the investigating judge has. So we thought long and hard and consulted about the question as to how we should deal with this knowledge that, as far as we're concerned, is very important for the case, but based on somebody else's decision was not allowed to be disclosed for safety reasons. And we believe that this was the most appropriate, decent, and proper way for the parties concerned to take note of that. So that's the explanation. We respect your decision. And if I've written this down correctly, is that for the time being, Annex 3 should not be submitted. I think that's a perfectly good solution. What I propose is that I do not distribute it, but if there should be a reason, for example, in case of doubt regarding what we said about that sentence, that you would then let us know, and then I could act accordingly. So I will not submit it. I will not distribute it, and we're perfectly happy with that solution, but I wanted to eliminate any misunderstandings about safety and risk. Okay, that's clear. Is that cause for the prosecution to speak about this? Well, a brief remark. The counsel explained very carefully why this was selected. She believes this is the right way to go. But it's very simple. That sentence is not supposed to be disclosed to your court, which means that the annex may not be submitted to your court now or in the future, because that is against the law. Quite honestly, I don't agree with that. It's my text, it's my sentence. I see no legal foundation for not doing. I respect your decision, but I truly disagree with what the prosecution just stated. That means that at this point, in any case, as I just said, you will not submit that document. The court will consider this in chambers, what you just said, and if necessary, we'll get back to you on that. Then we'll pick up again where we left off. Now, let me see. You were on page 142. And I will try to get to page 177 before the next break. We will continue with the third section of step 4. So the request for compensation and in exploring compensation questions, the ECHR has also considered circumstances other than simply measures that may have a compensating effect. For example, the ECHR also attributes value to the question as to whether the judicial authorities failed to take measures that could have led to compensation, whether they omitted to do so. In the Bikov ruling, the ECHR considered where the existing evidence is very strong and there is no risk of its being unreliable, the need for supporting evidence is correspondingly weaker. And according to, and in the words of De Wilde, a similar rationale should be applied in assessing the amount of effort required by judicial authorities. As indications increase regarding a witness potentially being non-credible or his statement unreliable, more efforts are necessary to give the defense the opportunity to ask questions. That would be the case if different statements by the same witness are inconsistent. I've already explained that the statements by X48 are inconsistent and that there are many other counterindications for the reliability and credibility of his statement, that the judicial authorities have a still greater obligation to take compensating measures. In the case of X48, we cannot deny that the judicial authorities have been negligent in this respect, and to explain this, we will need to go back in time to 15 January 2016, when the prosecutor applied to the investigating judge for X48 to be granted threatened witness status. Regarding awarding that status, X48 was interviewed that very same day by the investigating judge, which resulted in X48 being granted the status of threatened witness. At that point, the investigating judge should have served this status order pursuant to 226B to the defendant, and then based on 226A3 should have waited not with the case related, not with the status related, but with a case related interview. In a decision on 15 January 2016, the investigating judge decided accordingly. This reads that the application is granted, but that X48 will not be interviewed as long as the decision is eligible for appeal, unless the interview cannot be postponed. It was all okay until then. A report of actions and findings revealed nonetheless that the investigating judge did see cause to conduct the interview before the status order was no longer subject to appeal. The investigating judge considered the status in the investigation and the relevance of witness X48's knowledge for progress in the investigation. This is where things went wrong. One exception to the rule about waiting to conduct the interview is possible only if the importance of the investigation does not allow for the interview to be postponed. 226B3. That was not the case. The consideration by the investigating judge does not reveal that the importance of the investigation did not allow the interview to be postponed. All it reveals is that the investigating judge considered the progress of the investigation in its decision. That the progress, in so many words, related to this. That progress meant that delay was not allowed, or that it was truly necessary not to postpone the interview is something different, nor does the case file reveal that the progress of the investigation figured in any way whatsoever in the decision to proceed with the interview in the meantime. If the progress of the investigation does not allow for the interview to be postponed, the prosecution should have argued that. The prosecution did not. The prosecution did not even request an interview at that time, let alone the prosecution asking for that interview by means of an exception to happen sooner than prescribed by law. So the investigation until the date of the interview had merely asked that the status be granted. A few months later, apparently the investigating judge realized that she interviewed X48 without such a request. And that led to the consideration that the investigating judge viewed the request for granting status as an application to investigate, i.e., interviewing this witness. Much may be read into certain questions, but this cannot be read into the application to grant status because it's not there. Apparently, the investigating judge decided ex officio not only that such status would be granted, but that immediately before the status was no longer eligible for appeal, the substantive interview would be conducted before it theoretically being allowed. Moreover, if the prosecution asked that X48 be interviewed and indicated that the interview did not allow for a delay, the investigating judge could not have proceeded to interview X48 before the status was no longer eligible for appeal. In the case of X48, after all, it's inconceivable that the progress of the investigation would require an interview by the investigating judge. In other cases, this may be possible, conceivably in a situation where a witness could otherwise not be interviewed at all. For example, a witness that says he will make a statement only via the 226A through F procedure, so exclusively with the official status of threatened witness via an interview with the investigating judge. But that was not the case with for witness X48. In the case of X48, the JIT could and did apparently simply interview him without the 226A procedure. All questions that the investigating judge asked him and wanted to ask him could be asked by the reporting officer as well, and apparently X48 was also able to answer the questions from the investigating officer, and this eliminates the possible reason of progress in the investigation as a potential reason for not allowing the investigating judge interview to be postponed. The big difference between an interview by reporting officers and by the investigating judge in connection with X48 concerns the potential evidentiary value of the interview report, specifically because the evidentiary value is relevant. The rights of the defendant against whom the report could be used as evidence need to be respected. In the case of X48, the rights of the defendant were not accommodated at all. First of all, the prescription that the interview needs to be postponed in 226A was breached, and the investigating judge did not serve the status order expediently. The investigating judge, considering the application by the prosecution in violation with the prescription, decided to postpone serving the status order to client, and the law does not allow for this. According to the law, whether it's convenient for the prosecutor or not, the law requires that the defendant be notified without delay. No exceptions are possible. Not only should he be informed without delay about the status order, the defendant should also basically be given the opportunity to attend the interview. If that's not possible, then the prosecutor is not allowed to attend either. And the rule that if the defense cannot be present at an interview, the prosecutor cannot be there either arises from the equality of arms principle. The procedural opportunities for influencing and controlling that should be equal for both parties to the trial. Moreover, in this case, the presence of the prosecutor might compromise the impartial position of the investigating judge. Although the investigating judge did not attend, although the prosecution did not attend the investigating judge interview of X48, the prosecutor, basically against the law, did influence those interviews, contrary to later agreements with other anonymous witnesses in the application to grant the threatened witness status to X48. The case prosecutor was involved. The case prosecutor substantiated the importance of interviewing the witness, summarizing previous interviews with the witness, and even listed questions for the investigating judge which were asked, and that the investigating judge was not influenced or led in the questions is, in the view of the defense, completely implausible, but it's worse. If, pursuant to 226D1, it was impossible to allow the defendant to attend the interview and to ask the witness questions, the defendant should be notified as quickly as possible of the statement given by the witness and should have the opportunity to list the questions he wants to ask. Since 25 October 2016, client was known as a suspect, and from that moment, the investigating judge should have served him with the status ordered according to 226B and should have given him the opportunity to ask X48 questions. This was not done without an explanation. In fact, the defendant was not even notified about the existence of the witness, and if the investigating judge, who was also involved in many other investigative acts of the prosecution in this case, which seems unlikely, had not learned the name of the client yet, that was in any case not true on 9 November 2018, when the prosecution explicitly told the investigating judge client's name. Even on 9 November 2018, however, the status order was not served, and client was not had no opportunity to question X48.
Only on the 29th of January 2019 did the investigating magistrate account for the fact that she'll leave the accused in uncertainty in her records. She didn't say why she will do it, why she did do it, but why she will do that, because the public prosecutor on the 30th of November 2018 asked her not to inform the accused of the applications and decisions with regards to the status of other witnesses. So the request was made with regards to other witnesses, not with regards to X48. The reason given for not informing the defendant since the 30th of November 2018, and implicitly by extension not giving him the opportunity to ask questions or have questions asked, that reason given cannot justify that decision, because the reason, in the investigating magistrate's words, at heart comes down to the following. The investigation could be seriously impeded, and witnesses could be at additional risk, as could the accused, if the accused right now are informed of the fact that they're being investigated. The danger to witnesses, at most and under strict conditions, can justify not giving the witness's identity. However, it cannot be the reason to not inform the accused. First of all, it is impossible to see how the witness would be at risk if the accused were to know that they are the accused. We're only talking about the accused not being allowed to know that they are the accused. So how can a witness be in danger if the accused knows that they are the accused? How is that possible? In addition, the law does not offer room for questioning a witness anonymously, but then denying the defendant their rights because the anonymous witness is at risk. Quite the contrary, if the witness were to be at risk in spite of their anonymous status, the witness should not be questioned at all, not even as an anonymous witness. And the law provides explicitly, without exceptions, that the defendant should promptly be informed by means of the status decision being served, and the law also provides that they should be given the opportunity as soon as possible to interview the witness or to have them interviewed. And regardless of the fact, separate from the fact that the reasons given cannot justify the decisions, the reasons given also do not show why the investigating magistrate between the 25th of October 2016 and the 29th of January 2019, or at any rate between the 9th of November 2018, when the names became known, and the 30th of November 2018, when it was requested and not to do so in other cases, did not comply with these obligations. It's not clear why that was. How the investigation could then be impeded and how the accused would be at risk simply by knowing they are accused is also hard to conceive. It certainly didn't stop the JIT from publicly revealing the names and pictures of the accused less than 5 months later. What was a good reason to not inform the accused than that reason, since the press conference of the 19th of June 2019 certainly no longer justifies that our client wasn't given the opportunity to question X48 then or since. On the 19th of June 2019, so when the names were publicly announced, the status decision was still not served, and the client was not given the opportunity to interview X48 or to have them interviewed, nor were they given the opportunity to do so later. And there is no evidence of an explicit decision to that effect, certainly not of a good reason. The decision was not served until the 27th of January 2020, and the investigating magistrate did recognize that the law does not provide for this possibility, so to not promptly serve a decision, but considered that the defendant was not harmed in any legally relevant interest by delayed notification, since service is only intended to mark the start of the appeal period. The defendant, according to the investigating magistrate, is not harmed in their defense if service takes place at a later moment. We contest this. The principal purpose of the service might be marking the start of the appeal period, but that's not the only purpose. Serving such documents to a defendant also serves an information purpose, the right of the defendant to be kept abreast or to be notified of the course of the criminal proceedings against them and the legal decisions made in that context, because that gives them the opportunity to look into what rights they can exercise, like having a witness questioned, or at least it gives them the possibility of getting professional assistance. Client, in all those years, when he was left in extra statutory ignorance, was unable to use his rights. That means the defense was disadvantaged irreparably. Only on the 26th of January 2021 did the investigating magistrate, on the instructions of the court to question X48, that no opportunity will be offered for examination. It cannot be excluded that before the 26th of January 2021, it would have been possible to question X48. It's of course guesswork when it was still possible. We know that it was still possible in early 2016 apparently, and we know that in early 2021 it was no longer possible. The fact is that they chose to wait 4.5 to 5 years after that first interview, which took place in early 2016, before they even investigated the possibility of having X48 questioned by the defense. Certainly in light of the fact that there's always a chance that a threatened witness might not easily be questioned again, and there's always that chance, in failing to comply with mandatory rules, in part intended to give the defense the opportunity to question a witness as soon as possible, they've deliberately increased the risk of the defense no longer being able to question X48. So the 4 steps I've already discussed, and the European Court of Human Rights says, when you go over those steps, then you need to look at the bottom line and see whether there is fairness as a whole. So how are you to weigh all these various things? So that is what I'll be talking about now. Allegedly, X48 is an essential witness, meaning that our client, without X48's statements, should at any rate be acquitted of the charges. That means that any use of his statements, in the unlikely event that those statements are wrongly not excluded based on Dutch law, but it means that his statement should then be assessed based on those 4 steps of the European Court of Human Rights. I've already explained those 4 steps. The constraints for the defense were discussed as potentially compensatory measures. To then make an assessment or consider potential use of the statements of X48 in light of fairness as a whole, those constraints need to be weighed against any compensatory measures. Like we've said, the constraints were great. It is hard to imagine any greater constraints. The identity and the background of X48 are not known to the defense, but the Public Prosecution Service does know them. We have 2 pages of a statement from a witness that we know nothing about. We don't know who he is. We don't know anything about his background. We don't know about anything about his reasons to give a statement. We don't know anything about his preferences, his opinions, his role and position in the war, in connection with the war, about his past or his other activities. There is no evidence of a reason, never mind a good reason, to withhold his name and other background information. At no point and in no way was the defense able to investigate the reliability and the credibility of this anonymous witness. The defense was not allowed to interview them or question them in any other way. The hundreds of questions and sub-questions submitted in that context were not asked of the witness. Public Prosecution Service, to the contrary, apparently did speak to X48 directly and also via the investigating magistrate. The defense was not allowed to inspect the complete records or contents or other documents to do with X48 statements, in spite of repeated requests. In addition, there's no support for X48's statements, certainly no meaningful support. The assertions of the public prosecutor, if and to the extent it is usual, either do not fit in with what X48 has stated or only in a non-distinctive way, meaning that there could be an accidental or coincidental similarity. And if that non-distinctive material corresponds to X48, it regards non-essential parts of the case that we've disputed. Those crucial disputed parts are not supported in any way by the criminal file, and also that supporting evidence could not be investigated by the defense because all our reasons requests to that effect were dismissed. And those restraints or restrictions carry all the more weight because there are various facts that can be considered contraindications for reliability, which speaks volumes in view of the fact that both in an absolute and in a relative sense, we've only received very little information about and from X48. If little is known, then very little material can be assessed based on internal consistencies, external inconsistencies, so that there's still reason to doubt reliability is striking in and of itself. So it's clear from the aforementioned 2 pages that X48 on essential elements has been inconsistent and or factually incorrect, in part after leading questions. So 2 pages with statements that therefore don't just raise a lot of questions about the background and reliability of X48, but also about the contents and credibility of his statements. So those questions, in other words, those contraindications, arise amongst other things from the fact that X48, under oath, said that 3.5 hours before the MH17 crash, he saw a missile launch, that before that he saw 1 missile and no missiles after it, and that he saw less than half the people on site than he initially told JIT. So what exactly did X48 see? At what time? In what capacity? How honest has he been about it? How free was he to be honest? How honest did he want to be? How well was he able to see things? And where did what he saw happen? Would he put the X in the same spot if he'd been shown a different field or a map with other fields, with several fields? So 2 pages from a witness about whom there are many important questions. By the way, if the public prosecution service is looking for the truth, not just a conviction, it is very odd that the public prosecution service doesn't even mention the fact that X48 could not be interviewed. Never mind the public prosecution service concluding itself that much too little is known about X48 in order to trust their statements. Even though the public prosecution service, certainly in 2020, still had questions for X48. So all in all, we need to seriously take into account the possibility that X48 is unreliable and that his statements are not credible. And in view of the great seriousness and scope of the constraints we discussed and the contraindications, the compensatory measures should be on the opposite side of the spectrum. The greater the constraints, the greater the compensation that should be offered, especially if there's reason to doubt reliability. The measures to which the European Court of Human Rights usually attaches some compensatory value, whether sufficient or no, have not been taken. The national procedure of 226A through F, which, if strictly and completely complied with, could constitute a minimum of necessary compensation for the restrictions because of anonymity, was trampled on. Also, a minimum compensation in much of the much further reaching restrictions, going well beyond anonymity, would not be sufficient to arrive at overall fairness. With regard to an anonymous witness, the witness being interviewed by the defense could have carried great weight as a compensatory factor, but no opportunity was offered for questioning. So it is hard to see, especially since there are so many questions about X48 statements, it is hard to see how we can still arrive at sufficient compensation. The official record drawn up by the investigating magistrate, containing her opinion on the reliability of X48, is certainly not enough. It would not be enough if the investigation into reliability had been done correctly, but it's certainly not enough in view of the faulty, incomplete and incorrect way that assessment was done here. In the context of assessing the overall fairness of the procedure, one other aspect is very important. The rights of the defense of Article 6, Paragraph 3 have the important procedural purpose of achieving equality of arms. In the Koch case, the European Court of Human Rights considered that a public prosecutor cannot be present at the interview of an anonymous witness if the defense is not allowed to be present. And more in general, we can say that the right to equality of arms is infringed on if the public prosecution service has been given the opportunity to question a witness, but the defense has not been given that opportunity. With regards to X48, the problem is twice as big. Public prosecution was not only able to have the investigating magistrate ask questions, and those questions were answered, but investigating officers were also able to question X48 themselves under the authority of the public prosecution service. In short, even if national law would not compel the exclusion of the statements of X48, the only possible conclusion is that using the statements of X48 would constitute a violation of the right to a fair trial. So in view of everything I've said, we take the position that these statements of X48 should be excluded as evidence based on the Dutch Code of Criminal Proceedings, or that the use of those statements is not admissible and would constitute a violation of Article 6. So now I'm done with X48. And that brings me to Chapter 5 of Evidence Subquestion 1, which is the exculpatory evidence. I think that I'll do one half of that before the break and the other half after. So we've been explaining for several days now that and why the evidence presented does not show that the JIT field was the location from which the missile that downed MH17 was launched. That this is not shown by the evidence presented, however, does not mean that it didn't happen in that way. There's just no evidence for it. For the defense, of course, it's not necessary to prove what did not happen. It's very hard to prove that something didn't happen, and criminal law takes that into account. It is, amongst other things, for that reason that the Public Prosecution Service is supposed to prove what did happen, and if that cannot be proven lawfully and beyond doubt, the defendant should be acquitted. It is not necessary that the defense shows it did not happen in that way. We did wonder, what evidence there is that shows that MH17 wasn't downed using a missile from that field near Performaisky. So, first of all, we asked ourselves the questions: what would be necessary to prove lawfully and beyond doubt that the missile was launched from that field? In other words, aren't we asking too much? Aren't we being much too critical if we say that it's simply not possible? I will go into that first, on what you should expect as evidence if MH17 had been downed from that field with that missile. And then the fact that this evidence doesn't exist is exculpatory in and of itself. Then I will discuss the exculpatory evidence, which shows that MH17 wasn't downed from that field with that missile. That is the part for after the break.
First, the missing evidence that would be expected. Incriminating evidence if the missile were to have been launched. Forensic evidence. It is striking that there's no forensic evidence whatsoever that can support that a missile would have been launched from that location. Your court already indicated that it attached more value to forensic evidence, and the Dutch Safety Board also explicitly indicated further forensic investigation is necessary in order to determine the launch site. And the defense agrees with that, particularly in view of the context, agrees wholeheartedly. Objective, exact, neutral data are indispensable. Vague indications that mean nothing in a war zone, such as track traces, black patches, contrails, smoke trails, witnesses that can or cannot be influenced, particularly in this case, are of subordinate importance, and in this case, far from sufficient to declare the case proven. The only hard data that we have in connection with the firing field or the launch field are NLR, RMA, and AMAS-ANTE, and the calculations and assessment thereof on the part of the panel of American experts. The outcome of that has already been discussed. It disqualifies the JIT launch field. And for the rest, in terms of forensic evidence or objective, exact, and accurate data for the launch site, there is nothing at all. For instance, there are no traces on the JIT field that actually show, without us having to start guessing, actually showing that a missile was launched there. Such a hard conclusion is theoretically possible. Missile launches leave a substance behind on the soil. Soil analysis can show that a missile has been launched, and the soil samples have been taken by a journalist and later on by the JIT. But these samples are, you won't believe me, were not analyzed. Those soil monsters, the soil samples were not used, not in any way. Or in any case, the results were never included in the case file. The overview document says that those soil samples were not used because an analysis of a different soil sample in another site in Kramatorsk didn't lead to any useful information. Of course, that's no valid reason not to analyze the soil samples of the JIT field at all. First of all, we fail to understand why this wouldn't have had any chance of success simply because it didn't work out with another sample. Why not? And I'm talking about the samples of the JIT field. Why not at least try to analyze these soil samples? What have you got to lose? At most, it could show that no traces of a missile launch are found. Perhaps that's not what the JIT and the prosecution wanted to hear, but it is important to know. And then we can talk about the question what the results of such an analysis would or would not mean. Furthermore, it is being implied that the analysis of the Kramatorsk sample didn't lead to results, whereas it had been determined that a missile had been launched there because, so the reason why there was no result, because the time that had passed between launching and sample taking perhaps was too long. In the case of the Kramatorsk sample, the time between launch was 9 December 2014, and samples were taken on 9 July. So there were respectively 7 and 5 months between the launch and taking of samples. And the JIT says that the time between launch on 17 July 2014 and the date on which the JIT samples were taken, there was more time in between. Correct, 11 months. But what the JIT did not specify is that the time that passed between the date on which the journalist took the soil samples and the launch, that time is not mentioned. And the overview document in these considerations only refers to the JIT samples. The overview document doesn't state clearly exactly when the soil samples were received from which journalist. The English journalist, G2473, and another German journalist apparently took samples. If the samples of once the samples of G273 ended up with a JIT, those are samples that apparently were taken 4 days after launch. If the samples came from another journalist, then we cannot infer from the file when those samples were taken, but it seems to be before 9 January 2015. In any case, less than 6 months after launch. And of course, anything and everything can be said about samples taken by journalists. Those samples have not been taken by an expert institute. And the question is where those samples exactly were taken. But as the reporting officer says, this is the officer that interviewed G2473, he says, I think that would be very good when the journalist offers to give him the soil samples. One fails to understand that if the passing of time between launch and taking of samples could have played a role in the analysis of the residue of the missile, if that could have played a part, why those soil samples given by the journalist were not analyzed. And then finally, the investigation or the study into the Kramatorsk soil sample didn't lead to useful results. That doesn't mean that no analysis whatsoever should take place and would be useless. The NFI says that possible follow-up investigation can be applied to investigation material. And we asked about that. We asked our CO6 about this, and he said examples of further follow-up investigation are identifying and possibly comparative studies based on possibly new analysis methods and comparative methods that have not yet been applied at NFI. So it may be possible to conduct further analysis despite the passing of time, but those analyses have not been applied yet at the NFI. Why didn't the public prosecution consult another institute specialized in studying soil samples? We read nothing about it in the case file. It boils down to the fact that we have soil samples at the site of which the JIT believes that this is the site where the missile was launched. We've got that. And analysis is possible in two substances that could show that a missile was launched. And this analysis was not conducted because the analysis the NFI conducted on the basis of a different sample led to nothing at all. And this other possible analysis could have been conducted not by the NFI, but another institute. And this course of events, if you really want to know whether on that location a missile was launched, is impossible to understand. Something else we don't have, besides the hard data about combustion residue of book launch on the soil, what we also don't have are remainders of the book missile itself at the JIT location. After a launch, the book missile loses a cap. We learned this from the former army commander. And this cap would have remained behind, and this is to be expected. I mean, during war actions, unlike a training situation, in during war actions, you're not going to start looking for a cap, and the cap was never found. That doesn't mean to say that no missile was ever launched. But if a missile was launched, such a cap could have led to a strong indication thereof. Nor are there satellite images showing a boat tailor or a book missile launch from that field. There are no satellite images at all of 17 July 2014, or in any case, no images that give us any significant information in connection with this question. As far as we know, the only satellite images on which something seems to be visible, I emphasize the word seems, are the satellite images of the United States. However, we do not have them either. We asked for those images specifically and repeatedly, knowing that what could be visible on those images, or would be visible on those images according to the US, could constitute hard irrefutable evidence. The defense is absolutely convinced that this evidence has to be exculpatory evidence. I'll explain that. But unfortunately, we didn't receive these images either. From the description of the images, which is also why I believe that this is exculpatory evidence, from the description of the images, we can infer that, even though the conclusion is drawn there that it was a book missile, we can infer that the launch of the missile with which MH17 was downed cannot be seen on those images. The memo describing these images reads, "At the time that MH17 dropped out of contact, the U.S. intelligence community detected an SA-11 surface-to-air missile launch from approximately 6 kilometers south of the town of Snitsnoy in eastern Ukraine." So when MH17 lost contact, when MH17 was struck, according to the Americans in that area, a launch is visible. The visible launch cannot be the launch of the missile that struck MH17, because that missile must have been launched before that. The launch visible on the US images is only detected afterwards. This may be the launch of the Strela 10, as discussed by my client. Could well be possible, or a different missile. But a launch of the missile that struck MH17, that simply cannot be the case. Nor are there any radar images showing a book missile. The public prosecution has done its utmost to explain why, nonetheless, it could be possible that there was a missile, but that it simply wasn't visible on the radar images. As the prosecution says, it may well be possible that no missile can be seen on radar images, but should there have been a missile, it could have well been possible that the missile was visible on radar images. The question that seems to be more meaningful is not whether a missile can be missed on radar images, but what the chances are that a missile would be seen. The answer is not put forward in the case file. What is clear is that in the area around Pervomaisky, no book missile launch was detected by a radar. And whether a book missile can be seen on radar images of another area is something we simply don't know. And there are no radar tracking data showing the activity of a book teller. This topic has led to some confusion and lack of understanding before, which is why I'll explain this once again. A teller has its own radar. And if the teller is operational, for instance, in connection with the launch, the radar will transmit a signal. The signal is then received and registered by different systems, such as AWACS of the NATO or Ukraine's own radar tracking devices. RCO2 explained to the investigating judge that the teller is visible for satellites and other detection systems as soon as the radar of the teller is activated, and also that these observations are registered and stored. We asked whether it could be checked once again whether these registrations are really no longer there. Your court considered that since the Ukrainian authorities would have indicated that they do not have any other information other than the information that had already been made available to the JIT, that a repeated request would be useless and therefore was dismissed. We have to assume that the radar tracking devices, even though they did exist according to RCO2 in any case, but that these radar tracking devices did not register any radar activity in the vicinity of the JIT launch field. In short, none of the specific devices to that effect, including NATO AWACS or the Ukrainian radar tracking systems, none of these instruments picked up on radar activity of a teller radar. The JIT launch field was right alongside the front line and most probably was within the range of Ukrainian radar tracking systems. And in view of that, the fact that such registrations, that we don't have them, that is quite telling. And it supports the position that there was no teller operational in that area. Drone images. Drones are still being used a lot in the context of warfare, and that was also the case in 2014. Also to gather military intelligence. It was also used by Ukrainian armed forces. The Ukrainian army commander said that they had to write off a couple of their drones in the period before 17 July 2014. Nonetheless, apparently there are no drone images of the, in inverted commas, the book teller on or near the open field that the JIT considers to be the launch field. That is what is possible, but it's quite striking, and it supports the position that there was no book teller. What we also don't have is intercepts showing that the alleged book missile was launched or had to be launched. No single conversation giving orders to that effect, or is being discussed, or is being considered, or passed on. Nothing at all. The prosecution tries to explain that by saying that the telephone conversations cannot clarify this situation because from that moment on, it's silent on Karchenko's intercepts. As from 14:10 p.m., we no longer hear him on the intercepts. And Pulatov, we don't hear him anymore after 13:36. Radio silence. I already explained that there was no radio silence and that Karchenko's phone, client's phone, and other people's phones were used for telephone conversations, but those conversations were not about a book launch or an order to that effect. And there are more than 10,000 other intercepts of DPR armed forces that we have. None of these conversations talk about an order or actual observation of the launch of a book missile. If there's anything we can derive from that, it is that such an instruction was never given and that those observations were never made. And as we said before, that we have requested telephone conversations with the Ukrainian armed forces, but we never received them. Other witnesses. There are no statements of reliable, credible witnesses, and I'm not referring to M58 and X48, that say that they saw a missile launch from the JIT field. We requested to question the owner, the user, and other neighbors of the farm field as witnesses. If anyone could know more about it, it would be him. We would have wanted to ask him, and we discussed this explicitly in November 2020 at the court hearing. We would have wanted to ask him whether he saw or heard a book missile, or whether he knows how the black patches came about, whether he knows whether and why there was a fire there, and whether there was fighting in that area, and by whom and when. We don't know on whose side the owner of the field was, where his loyalty is, what he saw, what he did not see. The fact that we requested to hear him as a witness underpins the conviction that our client has that no missile was launched on that field. The risk to question this witness, whom we do not know who he is, what he could say, we would never ever have taken this risk otherwise, because if there would have been a missile launch on his field, this request to examine the witness could have led to incriminating evidence. The JIT apparently decided not to question the owner of the field as a witness. In any case, the results thereof are not included in the case file. And our request had been granted, but unfortunately we haven't been given the opportunity to question the witness, because it turned out that the witness most probably was located in eastern Ukraine at the time of the request, and the investigating judge didn't consider it to be responsible to examine the witness. Another witness that we would have liked to question, because he was near Pervomaisky and even near the checkpoint, is the witness who is being called Umka. I'm not going to mention his name. The court had granted this request despite the prosecution's request to dismiss this request, but we weren't able to question the witness because the Ukrainian authorities had indicated that it wasn't possible to contact him. A witness that we were able to question, G2473, on 17 July 2014, was not near the JIT field and did not observe a missile launch, but he says that he did talk to someone there who was in the area. This was the person with the combine, the harvest machine. This was the person that G2473 encountered at a stone's throw distance of the JIT field, and he reports on this. He says, this guy has been working that day, I think. Had he been working that day? I can't remember. Maybe he hadn't been. Anyway, we questioned him about this. Did you see a missile launcher? We basically told him why we were there, and he said, no, I didn't see anything. There's no missile launcher around here. What the combine driver did see was that there was scorched patches in that area. But the causes thereof, well, this witness can't tell us anything. If this patch would have been caused by a missile launch, you would have expected a different response on the part of this combine driver. G2473, by the way, after he arrived at the JIT field on 22 July 2014 and stayed there for a while with a taxi driver and a colleague journalist, he saw the checkpoint at the field. The DPR armed forces let him through without any difficulty whatsoever. It was so easy and smooth that G2473 visited the field the next day again. If on that field, just a couple of days earlier, a missile would have been launched that struck MH17, then one would expect that the armed forces at the checkpoint would have kept an eye on that field in the days after 17 July 2014 and would have made sure that journalists couldn't take their time to make videos and take soil samples. In short, we can infer from the statements of G2473 that the DPR armed forces were not intervening and that they were okay with the fact that a journalist was rummaging around, making a video and taking soil samples, and that the combine driver did not see a missile launch on the field next to the field where he was harvesting. All this doesn't have to mean that the missile was never launched from that field, but it does seem to be the case. The witnesses of whom we suspect that they should know whether or not a launch took place on that field on 17 July 2014. This is Umka and the owner of the field. Unfortunately, were never heard by the JIT as witnesses, and we haven't been able to question them either. The conclusion is as follows. If on the JIT field the Buk missile would have been launched that struck MH17, you would expect there to be more evidence than just black patch, track traces, a contrail, smoke trail, and two unusable witnesses. You would have expected more forensic evidence, that soil samples would have been analyzed in order to try to prove a missile launch, that residue and remnants of the Buk missile would have been found, that there would be satellite, radar, and or drone images of the tailor on that field and of the launched missile, and that there would be registrations of radar activity of the tailor, that there would be telephone conversations and other witnesses that could show that from that field a Buk missile was launched. The fact that none of this exists supports the conviction that it didn't happen there, that no Buk missile was launched there on 17 July around 1620 hours. This position is also supported by other pieces of evidence showing that on that date, from that field, no Buk missile was launched. I will be discussing that after the break. That is, if this is a good time to take a break. Yes, excellent, says the President of the Court. It is 20 to 3. Perhaps 20 minutes is too short. That's fine for me, says Counsel. I'm also looking at the interpreters. Is 20 minutes okay? Just a bit more. Okay, fine. We'll continue at 3:10.
All rise. Please be seated. Mr. Tendusgate, thank you very much. Now, the final but substantial section for today. At a certain point, though, I'm going to ask you to skip 2 pages. Well, that will speed things up. As for the exculpatory evidence, not for lack of other evidence, but in this evidence. First, the statement by our own client, obviously. We mustn't forget that in this account. He stated that on or around 17 July 2014, he did not personally see a book, nor did his subordinates report to him about this. He also stated that around 4:20 p.m. he was in the area of Performaisky, the general area, but when he was heading south, he heard that the Strela 10 was launched at the location that he's drawn here. We've shown this a few times before, but I'm showing it to you again here to refresh your memory. This is where he was. He says it's just below that black diamond shape, and that object inside it is the car he was driving. If a book missile had been launched from the field that the charge concerns, which is right nearby the car you just saw, then client must have heard that and might possibly even have seen it, and client did not see or hear a book missile as stated. So that is intrinsically exculpatory evidence. The statements by the other 3 defendants in this case are also to be labeled as exculpatory evidence. On 28 July 2014, during a press conference, defendant Gierkin stated that the separatists did not own a book system, so he could not possibly have ordered that the MH17 be shot down. Over the years, he has repeated this denial several times. Defendant Kharchenko also stated that, as far as he knew, the separatists did not have a book system. And finally, of course, Dupinsky, who also denies any involvement in the downing of flight MH17. We also have witness S40. At first, he seemed like a witness for the prosecution, or rather an incriminating witness. Based on his statements, S40, a regular soldier fighting on the side of the DPR forces, seemed to state that he had seen a missile being fired from a field near Performaisky, and that afterwards he saw the aircraft drop from the sky. For that reason, on 3 November 2020, we requested that we be able to interview S40 as a witness. The prosecution objected, but our request was granted. At some point after the request to interview S40 was granted, but before we were able to interview him, the prosecution interviewed him a 5th time, not via the investigating judge and without including the defense. Based on the 6th interview with of S40, that's before the investigating judge, where the written questions from the defense were asked, it appears that the S40 is in fact an exculpatory witness. During the interview at the investigating judge, S40, at a written request from the defense, drew where he saw a missile being launched, which I'm going to show you now. This clearly reveals, I'll leave it because I'm going to point it out again, this clearly shows exactly where S40 said he saw a missile being launched. Initially, during one of the JIT interviews, he drew the location slightly more eastward. A is where S40 was located. B is the spot where the B2 is where the missile was launched, and B1 at the spot where the missile was when S40 saw it in the sky. That is not the field near Performaisky, which I'm showing you now. that is believed to be in this red circle that I'm showing you now, inside the red circle. The spot that S40 draws is, therefore, a different spot than the JIT and the prosecution focused on. And that S40's statements do not support the JIT location might be why the prosecution reached the decision that initially seemed somewhat remarkable, the decision not to discuss this in its address. And it's actually very interesting that S40 defines a location that relates more to client's statement and the statements by the other exculpatory witnesses. And what S40 could that perhaps be the Strela 10 that client mentioned? The answer is it certainly could. It's perfectly possible. The location where S40 said he saw a missile head into the sky is closer to the location where client said he saw a Strela 10, which is indicated by the second red circle. So that's the B2 location where, according to S40, a missile headed into the sky is closer to the red circle where clients said that he saw the Strela 10 head into the sky. It's closer to that than to the other red circle, which is the JIT field. See, all these pages are worth viewing. Moreover, S40 stated that he saw a missile fly and that 10 and later on 5 to 7 minutes later, there was an explosion in the sky in which the large aircraft was hit, a Buk missile, and the sources differ somewhat on this, but a Buk missile takes about 32 seconds from launch to impact. And for the clerk, please indicate approximately 32 seconds because some sources say 45 seconds or just under a minute. So approximately 32 seconds compared with 10 minutes or 7 to 5 minutes. That's quite a difference between the launch that S40 observed and the moment of impact. So much time elapsed that it would appear that S40 saw a different missile than the missile that apparently must have been launched from a different location a few minutes later and hit the MH17, of which S40 appears to have noticed the explosion in the sky. Based on the time elapsed between the launch and the explosion, according to S40, we may infer that that other missile could be the Strela 10, and nothing in S40's statement impedes this. During his interview, S40 mentioned the noise that he heard when the missile was launched. Based on the noise, I cannot determine which type of anti-aircraft missile could have caused that. So the noise could, and these are my words again, the noise could also be compatible with noise from a Strela 10. The launch S40 did not see the actual launch system because, as he said, a row of trees separated him from the launch system. As for the missile that S40 saw, he said it was larger than a man-pad. This holds true for both a Buk missile and a Strela 10. Regarding the question, based on which observations did you conclude that the trail came from an anti-aircraft missile, S40 replied, I also saw how small, I know what small man-pads look like. Afterwards, the investigating judge asked, can you generally, based on the inversion trail, determine which types of anti-aircraft missiles could have caused this? S40 replied, I cannot tell you what brand, but I can tell you that it's from a heavy long-range anti-aircraft system. So both the Strela 10 and the Buk Taylor would be eligible. The investigating judge said, you mentioned man-pads, and S40 explained a man-pad is something you can carry on your shoulder. It's transportable. The investigating judge wonders whether their trail looks entirely different, and as 40 said, they leave the same trail, but it's very small. Then the investigating judge asked whether S40 can distinguish a strela from the strela from a book missile, but apparently S40 does not seem to see this as a strela 10, but as a manpad, which is a strela 3. That's also a manpad. The investigating judge merely used the term strela. And this section is about the manpad. He's talking about this, and then the investigating judge asked whether he could distinguish the trail from a strela to a book, or do they resemble each other too much. In S40 answered again, yes, I can easily tell them apart. A book is a category of heavy anti-aircraft system. Whether a book is a comparable system is difficult to say. They have reactive jet engines. Both a book and a strela engine have reactive jet engines. Excuse me, I should call this a strela 10 to be consistent. So it was a strela 10 missile was mentioned. So according to S40, the missile and trail that he saw did not come from a manpad strela 3, but from a heavy anti-aircraft system missile with a reactive jet engine. As to whether it came from a book teller or a strela 10, S40 cannot say, because according to S40, they resemble each other too much. So it's the trail of a book missile and not of a book teller. S40 stated that he observed one launch, not two. So it appears that he saw the strela 10 launch, in which case, since he saw one missile, he did not see a book missile. Even without assuming that S40 saw the strela 10, even then we know that S40 did not see a launch from the jet field. So whatever it was that S40 saw, it was not the launch of a book missile from the field that the charge is concerned. And knowing that the missile that S40 saw was not launched from the jet field, and S40 therefore did not observe a missile launch from that field, we may infer that no missile was launched from that jet field. S40, who was in close proximity, as a regular soldier and knowledgeable about such things, after all, should have heard or seen that, and S40 did not. So S40 statements are therefore also exculpatory evidence, and quite honestly, I note that the same as it holds true for all other witnesses in this case file, the question is whether S40 is a reliable, plausible witness. I am not suggesting that we do not see him as reliable or plausible, but the reliability of S40 was not investigated by us without limitation and directly, and was interrupted prematurely. So it's difficult to say anything as to his reliability or plausibility, and perhaps the prosecution may argue that S40 is mistaken and that he saw a missile on 16 instead of on 17 July, and is thereby confusing the events from the 17th. We cannot rule that out. S40, like M58, confuses dates now and then, and like M58, he is then propelled toward the 17th by the interviewers. So at his fifth interview, S40 stated, just as he did repeatedly in previous interviews, he states for the second time that he saw the system initially on the 15th or 16th of July 2014. This deviates from the interpretation by the JIT, and the interviewer intervenes and, in quotation marks, corrects S40 by saying, "May I say something? The book that shot down the MH17 was only introduced on the 17th in the afternoon." And in addition to this leading question, these leading remarks, which don't qualify as a question, S40 will also have been known about the JIT in prosecution media campaign, so it cannot be ruled out that he was influenced by leading interviewers and information from the media. If we assume that S40 is therefore not or is insufficiently reliable or plausible, then his statement does not, and that his statement does not declaring the charge, impede declaring the charge is proven, then we can say the same about M58. He was
So witness V48 is one of the smoke plume witnesses that can be found in one of the footnotes of the prosecutor's address. I've already discussed that the value of the smoke plume witnesses and photos is limited because if they can even be used, to the extent they don't describe something else or something at a different site, it only shows that somewhere in the direction of Somagila something created a smoke plume, and it doesn't say much because other things could have caused it, like agricultural fires, hostilities, including the launch of Australia 10. However, witness V54 stated that, unlike other smoke plume witnesses, saw the location where the smoke plume occurred. He said he was much closer than the other smoke plume witnesses were, or seemed to have been. So the location of the smoke trail described by witness V54 does not fit in with the charges, but the location he describes could fit in with the location designated by our client where Australia 10 was launched. Because V54 stated, and I quote, "And because I was going in that direction, I looked at the trail, I had the impression I was moving more in that direction," and that the witness points to a place eastwards of the white road running from north to south in the field of vision drawn by them. But later I've heard that it happened on this side of the road. Here the witness points to the west of the white road. I'm saying that based on the stories I've heard, but I had the impression that it was more over on that side, and that the witness indicates somewhere to the east of the white road. And I'm again going to show you that map with both the JIT field and the location of the Australia 10 launch, according to our client. And you see that the Australia 10 location, the right-hand circle, is more easterly than the JIT location, which is the left-hand circle. It's just like V54 described. So it's a good thing that V54 was not fazed by all those stories he later heard. Otherwise, he might have drawn or designated the wrong location, and that would then wrongly be seen as support for the JIT field. But fortunately, he made it clear what he thought himself. So we can adduce from V54's statement that the smoke plume did not arise on the JIT field that the charges refer to, at least that a launch did not take place there that caused a smoke plume. Then witness S45. That was the biggest surprise in the file, and we were only informed of it right before the prosecution's address. Until then, nothing had been added to the file on this witness. We don't know a lot about S45. The only substantive document we have is an official record of findings concerning information provided by a former member of the 53rd AAMB that was drawn up by the police, and we'll call that the summary or the redacted report. So the information that we have from S45 based on that summary is sufficient to conclude that witness S45 could be a crucial witness. S45, of course, says that they were there as part of an army, but that no Buk missile was fired from that spot. We have repeatedly asked to be allowed to verify the reliability and credibility of S45 further, and we've done that. And we wanted to do that in several ways. By interviewing them, by accessing one or more documents beyond the summary, by inspecting files on special investigative powers used, or other documents which could show how information was covertly obtained. So we asserted we wanted to investigate, and I quote, connected to the contents of what S45 said, where S45 was, according to his own statement at that moment, the moment where he did not see a missile surrounding the crash, what he saw himself, or what other sources of knowledge he has, what his exact words were every time, and what nuances or emphasis he did or did not include, and many other questions. And in connection with the reliability of S45, under what circumstances, S45 spoke about the fact that he did not see a missile fired, how often he said it, who he said it to, at what moment of the day, and in what context. And what S45 said exactly later during the interviews, how often and based on what questions, what information he was provided with, who asked the questions, under what circumstances those questions were asked, what the dynamics of the interviews was, and what means the public prosecution service used, and how this information was acquired. So based on these questions, amongst others, we were hoping to determine, and where necessary also substantiate, what S45 said he saw exactly, and what the sources of his knowledge were, and what information was more or less reliable. In order to get answers to these questions, on the 1st of November of last year and the 8th of December last year, we asked to be allowed to question S45 as a witness, and respectively to get copies of the reports and records describing the investigative powers used, and also describing the results of the use of those investigative powers, the records of the interviews and conversation with witnesses, etc. And we refer you to the reasons given there, which you can find in the pleading notes. We ask you to regard the contents as repeated and inserted here. Unfortunately, and I mean that from the bottom of my heart, that did not mean that the defense received more documents or was allowed to question S45, and that's a problem, because we have a lot of questions about what exactly S45 said. And now that we cannot investigate this further, and since we cannot ask him, we can only try to determine, based on the summary, what S45 said under what circumstances. We can deduce from the summary that S45, apparently without his knowledge, was heard or seen by an investigating officer, and that he then made statements which come down to the following: that he was near to the place where MH17 crashed, that he was there as part of the Russian army unit of the 53rd AAM Brigade with a lot of specialist book knowledge, of which it has been said that they were the unit involved in downing MH17, and the unit was pointed out in relation to the incident, that with regards to distance, the plane was close enough to down with the radar, and there was a command post on site, but that they didn't shoot, there were no missiles, that he did not see a book launch, even though if a book launch had taken place within 50 kilometers of him, he would have heard and seen that. This is very relevant exculpatory information. Someone saying that as part of the 53rd Brigade, the unit, after all of which the JIT and Public Prosecution Service say that it was involved in downing MH17, that as part of that brigade, he was in the proximity of the crash site and was in a geographic position from which MH17 in theory could have been downed, but even though he is someone who would be expected to notice a missile launch in view of his training and background if it had been launched, he did not see or hear a missile launched in close to him. This information is essential and exculpatory when it comes to assessing sub-question 2 of the indictment. If MH17 was downed by a book missile, was it a DPR missile fired from that field near Pervomaisky? Apparently, and according to the observations, and therefore the direct knowledge of S45, it wasn't within a radius of 50 kilometers from where he was. If S45 was near the field, in the field near Pervomaisky, and if you believe S45, then the charges cannot be proven. With regards to that first point, so the location of where S45 was relative to Pervomaisky, well, from the limited information that we have, it can be deduced that he was probably near the field, near Pervomaisky, because he was both close to the crash site and close to a command post not too far from where MH17 was flying. We weren't given any more details, because, of itself that doesn't say that much, but more details, in spite of our request, we did not receive. So we need to at least take into account the possibility that S45 was near the JIT field. And with regards to the second point, about the credibility of S45, based on the limited information available on that subject, it is to be suspected that the information obtained covertly from S45 is reliable and credible for various reasons. First of all, why would someone, when they don't even know that someone else is listening in, lie? In general, we can say that when someone says something not knowing someone else is listening in, that's probably more reliable than what is said by that person who fought in a war, not on the Ukrainian side, when faced with an investigating official, part of a team that the SBU is also a part of. So someone who allegedly fought on the DPR side says something without knowing that anyone else is listening, and then in general you could say that that is more reliable than what he says to, for example, an SBU official. Secondly, S45 initially said things that, from a Russian perspective, could have been considered taboo. For example, he says that the 53rd Brigade was also in East Ukraine. That he says that, in and of itself, justifies a presumption that S45 at that moment is not saying something that he thinks someone would like to hear. He's simply saying how things were. Thirdly, no good reasons are known to doubt the reliability and credibility of the covertly obtained information. Certainly the fact that S45 later apparently didn't want to confirm the accuracy of that information when asked by the JIT is not a reason to doubt the reliability and credibility of the covertly obtained information. Because it makes sense that a witness holding such crucial information is unlikely to tell just any passing SBU or JIT officer. As far as we know, S45 was not offered a witness protection program, unlike M58. No application was even made, as far as we know, to have S45 questioned as an anonymous threatened witness by the investigating magistrate. Certainly the defense was offered no opportunity to ask S45 any questions, but the public prosecution service for many other witnesses that had any kind of incriminating statement, did make such an application, that they be heard or questioned as anonymous witnesses. Such applications were always made on very general grounds, related to summarize the war and other threatening circumstances in the broadest sense of that word, that those grounds would also apply to S45. Nevertheless, no 226A application was made for S45. S45, who had exculpatory information, who seems to have had that, was interviewed just regularly, so without this 226A application. It was questioned by an unknown JIT investigative official, possibly an SBU official, so that circumstances as well supports the position that the later denial of S45 is not a reason to doubt the accuracy of his earlier statements, which were covertly obtained. In other words, a witness whose information shows that no Buk missile was fired from near Pervomaisky, when there are no good reasons to doubt the reliability and credibility of this witness. So these statements of S45 therefore preclude the charges being declared proven, since it contradicts the element of MH17 being down with a Buk missile fired from that field near Pervomaisky. If the court feels differently, and if the court is considering not having S45 statements preclude the charges being declared proven, then again we would conditionally like to request an interview with S45, because in that case, at the very least, the question of S45 being reliable should be investigated, especially whether his earlier information, covertly obtained, is more reliable than the statement he later gave to the JIT, and whether he was near the JIT field or not. Then another subject to do with exculpatory evidence, that is Almas Antai, their calculations, and the panel of American experts. I would like to ask you to skip paragraphs 534 to 538. I will remove them from the digital version. I'm not going to read that out because when I wrote this, I didn't yet know how clear my colleague was going to be on the subject. So I'm going to leave that for what it is, and I'm just going to read out that those findings don't allow any other conclusion, and that the missile that downed MH17 cannot have been launched from the field referenced in the indictment. And that was paragraph 539 that I was reading out there. Then I will continue with the missile tube, that is 5.9. That is another remarkable part of this file. That missile tube has also been called the casing or the shroud, and this tube was found in April 2015. On the 24th of May 2018, this was still the missile tube of the JIT, the smoking gun. And in the current circumstances, that might not be the best phrase to use, but it does cover what we're talking about. This was the smoking gun. Gentlemen, I'm going to tell you more about the type of missile that was used to shoot down MH17. As we know, it was a Buk missile from the 9M38 series. In part of the plane wreckage, as well as in bodies of victims, and also on the crash site, different parts of the type of missile were found. I'm going to specifically talk about two parts of that Buk missile now, called the venturi and casing. The venturi is the exhaust of the missile, and by casing we mean the shell of the missile engine. A venturi and the casing were found in eastern Ukraine. And also in June 2020, when the Public Prosecution Service explained the investigation, this tube was given a lot of attention. However, and we've gone into this before, but from the eventual phrasing of the Public Prosecution Service, it doesn't become clear whether the Public Prosecution feels that this is the tube of the missile that downed MH17 or not.
We didn't get a real answer, even though we asked for such an answer. And the prosecution's submission did not even touch upon the casing. In view of the role the casing seemed to play, this seems strange, because whatever this casing is, in both cases, so whether or not it is a casing, the casing of the missile, in both cases, the casing is relevant. If the casing was not the casing of the missile that struck MH17, that means, apparently, according to the prosecution, remnants of Buk missiles will have been found in the area that are not linked to MH17. That is relevant for the evidentiary value of the casing and other elements of the missile. That evidentiary value is 0. We discussed this with respect to evidence question 1. But if the casing was of the missile that struck MH17, then not only for question 1, but also for this topic, the launch site, it is relevant and interesting. I'll explain this. The casing that arrived in Gilserij on 30 April 2015 for the benefit of the JIT investigation had a unique number. And with a letter of request of 3rd of May 2018, this number was put to the manufacturer of the casing in the Russian Federation. The answer of the Russian Federation was not yet known at the time of the press conference, of which I showed you part of the footage. That followed shortly afterwards on 17 September 2018. The summary of the Russian answer, according to the JIT, is as follows. According to the Russian authorities, their own administration showed that the casing and exhaust of Venturi were part and parcel of one and the same Buk missile of the type 9M38. This missile would have been manufactured late December 1986 in Moscow. The missile had the unique assembly number and military missile number mentioned and stipulated in my pleading notes. According to a page from a logbook, the missile with these two numbers was shipped on 29 December 1986 to Army Section 20152. This Army section, according to the Russian authorities, in fact was the 223rd Anti-Aircraft Missile Brigade of the 38th Army of the Military Circuit Prikaparty in the province Ternopil in what was then the Soviet Republic of Ukraine. Until the disintegration of the Soviet Union in 1991, this brigade would have remained stationed at this same location. After that, the brigade became part of the Ukrainian armed forces, and hence, army units of the Russian Federation did not have the missile of the 9M38, the number of which I have written in my pleading notes but not mentioned, and so it doesn't appear in the administration of the Ministry of Defense of Russia. End of quote. In other words, according to the administration, the casing on which we find the unique number was supplied in 1986 to the army unit that is now part of the Ukrainian armed forces. In order to substantiate this information, in the reply to the letter of request, a letter of the Ukrainian General Colonel was forwarded, as well as copies from the logbook administration of accepted production from the files of the technical documentation of the missile and missile engine, and 2 witness statements of a technical engineer and also the deputy head of the military representation of the Ministry of Defense. In response to this, the SBU turns to the Ukrainian armed forces. The answer, in which we read, amongst other things, that a missile with this number was never registered in Ukraine, says, in view of the caveat that was explicitly made, says very little. The number has simply not been found, considering the records available. This is the caveat that they make. And so it all depends which documents were indeed available. So if nothing was available, then of course the answer is meaningless. Which documents were available and were consulted? Well, that doesn't become clear from the letter. A later letter from Ukraine does clarify matters. This letter shows that the relevant documentation simply doesn't exist. That the number wasn't found cannot, by definition, mean that this number was never registered in Ukraine. It only means that it cannot be found in the available documents. And which documents were available is something we can derive from a later letter, even though it has been described rather cryptically. The letter reads that the information about the Buk missiles that were there in the period from 1986 to 1991 is absent. The information is absent. And we read that the Buk missiles that were there in 1991 would be registered in a book called Record Book Form 32. Unfortunately, we cannot find out what this book says and contains because the book was destroyed because the limitation period had lapsed. And the reason for which the document was destroyed has not specified. A copy of the record book, as from 1991, has been provided, has not been incorporated, and a PDF of the English translation has been included in the file. In that translation, certain numbers or descriptions are missing because 85 sections are illegible. It only says illegible. And we don't know to which date this book goes, but there are no data of after 2001, and the first page says starting date 2 September 1991, and 22 September 2009 is the end date. It doesn't say what the records contain of the period after 2009. And finally, the Ukrainian letter says, any other data on the handover, transportation, introduction into service of the 9M38 surface-to-air guided missile to Book M surface-to-air missile system is absent. Any executed documents are absent. In short, what we have is an English translation of a copy of a record book in which 85 sections are illegible. Only concerns the period from 1991 to 2009. What the book says prior to that date and after that date is unknown because it has either been destroyed or for unknown reasons is absent. And all the other information about the receipt, transport, and commissioning of the book missile and systems is, for unknown reasons, absent. Not really a denial that the book missile or the casing was in possession of the Ukrainian army, not a denial that could lead to the conclusion that the missile concerned on 17 July 2014 was not in possession of the Ukrainian army. That possibility remains a possibility. And in view of the fact that the Russian Federation has provided documents showing that the missile concerned in 1986 or 1987, I was hesitating about that when I wrote this, was supplied to the army unit that is now part of Ukraine. In view of the fact that those documents were supplied, there's every reason to believe that the casing that was found was part of a Ukrainian book missile. Even though it's strange that the casing doesn't appear in the prosecution's address, that could explain that decision. I have said this before. If the casing that was found is part of the missile with which MH17 was struck, then the casing is interesting for question 2 of the evidence, because that would mean that MH17 was struck by a Ukrainian missile and not by a book tailor that was possibly in the vicinity of Schnitzer and in the area controlled by DPR. So the conclusion is that all the exact forensic objective evidence is missing that one would expect if the JIT field near Pervomaisky would have been the location from which on 17 July 2014 a book missile would have been launched. Furthermore, more and more reliable witnesses, there are more reliable witnesses and more facts and circumstances that have been stated in a more reliable way that no book missile was launched at that point in time and at that site. I'm going to wrap up the topic of question 2, evidentiary question 2, that we've been talking about the past few days. We started by talking about the context on the basis of which many, understandably, have believed that if there was a book missile, it was the book missile with which MH17 was struck. We have discussed why the possible presence of a book tailor simply does not mean that if flight MH17 was struck by a book missile, it must have been struck by that book tailor that possibly was in the vicinity of Schnitzer. About that book tailor, we don't even know whether it could launch, nor do we know whether it launched a missile. And a book in that area was not that rare or unique that it must have been this book. Quite the contrary, if there was a book, it has to be viewed from the perspective that there were at least also 27 tailors and 150 book missiles that were in possession of the Ukrainian armed forces in that area. One may infer from the available telephone conversations that they pretended that a book tailor was transported, but if that was not military deception, the telephone conversations also show that the book tailor never launched a missile. Contrary to the many conversations in which they speak about transporting a book, those conversations do not talk about launching a book, and the DPR armed forces didn't even know how MH17 had been struck. The simple fact that the alleged DPR tailor could possibly have been driving in the direction of Pervomaisky around 2 p.m. doesn't make this any different. This is an obvious direction because the fighting was going on in that direction, and more material and equipment was being stored in that area. The facts and circumstances that we discussed in this context are so remotely connected to the charges that it cannot be considered to be corroborating evidence. And there's nothing that is usable, credible, or distinct that it could be used by way of corroboration for the charges, and that the book missile would have been launched from the field near Pervomaisky. I'm going to skip paragraph 566. The context we discussed and the facts and circumstances put forward by the prosecution by way of support appear to say nothing at all, because expert calculations have shown that the missile that might have struck flight MH17 cannot have been launched from the area around Pervomaisky. Pervomaisky is nothing more than a village between Schnitz and Saumogila, an area where there was a lot of fighting going on, where DPR, armed forces, had checkpoints and equipment. Pervomaisky has no link whatsoever with MH17. What remains are the witness statements of M58 and X48. And in connection with M58, there is such an exceptional number of indications that his statements lack credibility and are unreliable that for that reason his statements cannot be used as evidence. The only thing that remains is X48, and the use of his statements will be considered to be decisive, but that would be contrary to Article 6 ECHR. In any case, if the situation were to be different, we simply don't know enough about X45 to assess whether he's reliable. There are contradictions, inconsistencies, lack of credibility that we have in a couple of lines of statements that he made are not very promising for the outcome of such an assessment. Bottom line, there is nothing that could actually show that flight MH17 was struck by a Buk missile launched from the farm field near Pervomaisky. And it goes even beyond that, because the evidence that you would expect should things have transpired as stipulated in the charges is absent. There is no forensic evidence. There was no analysis of soil samples, nor have remnants or traces of a Buk missile been found on a JIT field. There are no satellite radar or drone images of a tailor on the field or of a launched missile. There are no registrations of radioactivity of a tailor. There are no telephone conversations, nor are there neutral, credible testimonies from which we can infer that the Buk tailor was launched from that field. But there is evidence that no Buk missile was launched from the field, and these are the statements of our clients, Girkin, Dubitsky, and Kharchenko. They have stated that as far as they know, no Buk missile was launched from there. The same applies to the statements of S40 and 54, from which we can infer that they observed a different missile launch on 17 July 2014. There cannot have been a Buk launch on the JIT field, but it could be a Strela 10 launch that our client made a statement about. And witness S45, without him knowing that he was being tapped, he talks about the role of the 53rd AM Brigade in a way that is at odds with the formal position of his boss, but it makes it very clear that this brigade did not launch the missile with which MH17 was struck. And then there's exculpatory evidence, conclusive evidence that the missile struck MH17 was not launched from the JIT field. And if we look at Amasante's calculations and the statement of the panel of American experts, the conclusion has to be that MH17 cannot have been struck by a Buk missile from this location. And if the casing that was found was from a missile, it must have been one launched from a different location and not the field near Pervomaisky. There's only one possible conclusion. The charges cannot be proven. The available evidence does not qualify to declare the charges proven. Another interpretation of the facts and circumstances that have been put forward is not only possible but also plausible and likely, more likely. Nothing shows in a reliable way that flight MH17 was struck by a Buk missile that was launched from a field near Pervomaisky as stipulated in the charges. Hence, there is insufficient conclusive evidence, because one cannot with a probability bordering certainty, determined that MH17 would have been struck by a Buk missile launched from a field near Pervomaisky. The available evidence and all the exculpatory evidence that the missile cannot have been launched from the field near Pervomaisky is insufficient to come to the conclusion and to be convinced that MH17 was struck by a Buk missile. There's insufficient conclusive evidence. What did happen, unlike what the JIT and prosecution have told the public for years, it does not become clear from the case file. And for the relatives and all the other people interested in the case, this is not a welcome, but it's a terrible message, and we realize this full well. But the evidence, whichever way you look at it, simply does not hold up. Since there's insufficient conclusive evidence for this part of the charge that MH17 would have been struck by a Buk missile launched from a field near Pervomaisky, we request your court to completely acquit our client, Pulatov. Thank you, says the President of the Court, for your oral arguments today. Thank you for your attention, President of the Court. So we're repeating ourselves. We're thanking everybody for their efforts, but that still remains the case. This is the 8th day of oral pleadings. We still have 2.5 days to go, which means that we will be proceeding tomorrow. We're suspending the hearing until 10 a.m. tomorrow morning.